the suit proceedings.
Because
I am seeking for rejection of Milot's
that's what
claim.
CRP.
That application came to be rejected. So now Milot's some further developments have been taken place. So
no, any further development will not have an impact on the impugned order.
Yes, Milot, I do agree. But Milot, if that is settled, if the matter is settled between the parties, then I may have to withdraw this. Therefore, at the present, Milot,
maximum a week's time, not more than that. This is matter on 26. No further time, because it is has not even seen the light of the day from 2023.
No. 10 days,
no.
Otherwise, I will proceed with that. There is no problem.
Actually, I want to do it right now, but anyhow, you're asking, it will be next week. Yes. This is matter on 26. Yes.
Number 51. 51.
Yes.
Can you take up next week on additional counsel?
And for the petition at any basis, they benefit in the next week.
At the request of both the councils, this is matter on 17th of December.
17th.
Have you informed the other side? No, I will inform. Please look at the note. I will not grant any adjournment without informing the other side. Yes, next. Serial number? 46. Yes. 2022 CRP. No, I understand. You please tell this also to her, not to you.
Yes.
The list is matter on 26, no further adjournments in 46. At the request of and counsel the petitioner, inter-alia only granted is extended till then. Yes. Yes. Comprehensive office objections, we will see. Yes, next, be here.
Page number 10, serial number 57 to 61.
61, my lord. Acknowledgement, my lord, I will produce next week, my lord, I will certificate a copy. I have already deposited every month. I am going to deposit 4,000. I will get a certificate copy.
This order is on 24/4/2024. It should have been filed by this time.
No, while the interim order is granted, there is no such acknowledgement is published. Interim order is granted subject to payment of every month. I have paid every month. I am paying.
Who appears to responded to this? Are they paying?
I'll take instruction.
This is matter on 28th at the request of the counsel petitioner. Inter-alia only granted is extended till the next. 60?
I informed you. It's going to be 2 weeks because of the
At the request of both the parties, as it is submitted that there is a likelihood of settlement. This is matter on 11th of December. Yes. Inter-alia only granted is extended till then.
Page number 11, serial number 62 to 69. Page number 12, serial number 70 to 77.
What is there to argue? It is not. It's not about the amendment. Even prior to amendment, also, as per the judgment of this court, that is what has to follow. You please argue. And again, I have to remember all the yesterday we heard, and today we'll pass orders. Please come with instructions. No adjournment. Yes.
Page number 13, serial number 78 to 81.
Serial number 78. 78. And last one, director to file calculation mark to both sides. Short date will respond to the also here. Short date will not.
Why is the date given today?
To file notice.
So why should another short date be given? How many times a matter will be listed?
He has applied for the order to trial court, not the deposit on the each date of hearing.
It's all wasting court's time, nothing else. This is matter on 29th, no further time.
Please.
At the request of the counsel the petitioner.
Please.
Inter-alia only granted is extended till then. Yes, next.
Page number 14, serial number 82 to 85.
84. Here for phone number 1. I informed the petitioner counsel. Yes, food infection.
When you want?
Before days.
This is not on 25th.
25.
Yes, at the request of, like, calls for the respondent. Intermodal, if it is there, extend it. Yes, next.
List 2, page number 1, seal number 1 to 3. List 2, page number 2, seal number 4 to 8. Page number 3, 9 and 10. List number 1, non-compliance of office subsection for first time, seal number 1, Hemant Kumar L. Havargi. Hemant Kumar L. Havargi, list 1, seal number 1.
No representation for dismissal tomorrow. Yes.
Seal number 2. HR Deshpande.
I'm going to be available to this time.
1 week, a week's time for complaints, default order. Next 3
Seal number 3, AS Party, Sabila Ahmad.
weeks time, default order.
Seal number 4, DR Party.
Yes, a week's time. Same order.
Seal number 5, Varsha S. Varsha E.
No representation for dismissal tomorrow.
Sorry.
Yes, 6
Seal number 6, Kiran Kumar, Hettiman.
a week's time. Yes, next.
Seal number 7, Jay Shetty.
Week's time.
Seal number 8, Satisha Sraju.
No representation for dismissal tomorrow.
20%. Seal number 9, HN Goldwadi.
A week's time.
Seal number 10,
All default orders in every case. Yes, 10.
Seal number 10, Vijay Madali.
Yes. Next. Same
Seal
order.
number 11,
11.
Vijay Madali.
Yes, same order.
Seal number
12.
12, GP Nayak.
Yes, we
A week's time. You complied with?
complied with serial number 2, my lords.
What about 1? Then counsel submits that the objection serial number 2 is already complied with. For complying with the objection is serial number 1, a week's time is granted, or else the petition shall stand dismissed without further reference to the court. Next 13.
Please.
Non-compliance of office subsection for third time, seal number 13.
No representation for dismissal.
21st.
Yes,
Seal
14.
number 14.
A week's time. Yes,
Seal number 15, Sadiq Purwala.
a week's time.
Seal number 16, Srinivas Nayak.
A week's time.
Seal number 17, Mahantesha Sirapat.
No representation for dismissal.
21st. Seal number 18,
Yes,
seal number 19, Malika Goswami Sirapat.
a week's time.
Seal number 20, Sachin Siakri.
No representation for dismissal tomorrow.
21st. Orders matter, seal number 21.
Last week of hearing, my lordship has permitted to file memo for conversion. I have filed it, my lords. I request my lords permitted to convert CRP into writ petition.
What is this order?
That under order 41 rule 19, my lords, application came to the judge. Against that, my lords, writ is matter. So I have to file writ petition, my lords.
That realized chapter 4, 2 years.
Sorry.
But a memo is fine. Where is that memo?
My lords, listed.
A memo is filed stating that against an order filed and passed under order 41 rule 19, they filed this revision where they're supposed to file a writ petition. Hence, the memo is filed seeking permission to convert the civil revision petition into a writ petition. Considering the submissions, the memo is taken on record. The petition is permitted to convert the same into a writ petition. And for the statistical purposes, that CRP is disposed to.
Please.
Yes, next. Next.
Seal number 22, Mrityunjay Tata Banki. Srinivas Bhattacharya.
My lords, R2C, my lords, will ascertain fresh address. Because it's for the third time that I'm already paid twice.
1 week,
Please.
a week's time in this also to pray the process. Report order. Yes. 23.
Seal number 23,
Week's accommodation, my lords, to file nursery.
Yes, yes.
CF is
A week's default order. Next. 24.
Seal number 24.
No representation for dismissal tomorrow.
20%.
Yes, 25.
Seal number 25. Vijay Sinha.
The week's time, report order. Next 26.
Seal number 26.
Notice to respondent, R11, returned as refused. Amounts to service of notice. This is CRP for admission tomorrow.
My lord, sir, kindly direct the petitioner to serve me the entire.
Please serve him a copy.
Only I serve the petition copy. Please.
Then counsel the petition shall serve a copy of the revision petition of the counsel for the respondent. This is matter for admission.
Along with annexes.
Entire set.
Please.
This is matter on Saturday.
Next week, can you give me, please?
Why?
Council is not filling that matter.
Why everybody nobody wants the date on 23rd. Why the court should work then? List is on 26th. Yes,
Order
please.
to be extended.
Huh?
If there is a interim order to be
Interim order, if it is there, look at it and extend if it is extended on last occasion. Yes,
Seal number 27. C.A. Shepherd. Suraj C. Pankaj.
Another RPFC was listed yesterday, my lordship, is between the same parties. Directed to be taken up on Saturday, my lordship. This matter is trying to be taken
it's on the maintainability of a plea. How does it matter?
Under section 94 of the Family Courts Act, my lordship, provides opportunity to file a petition, my lordship.
What is the interim? What is the order that's
We are
passed?
challenging the order for setting aside the criminal miscellaneous, order passing criminal miscellaneous, my lordship, awarding 2,000 maintenance.
That's what, whether it is an interim order
No,
or
no, it's final order, final order.
yes, list this matter along with give the number on 19th on Saturday. Yes, next.
23rd.
Yes.
Seal number 28.
No, sir.
Vijay Shankar
I
Srinivas.
have paid to PF today, no, sir.
Let council submits the needful is done. This is matter after service of notice, interim order.
Interim order is not there. I am seeking interim order, no, sir. I have deposited, no, sir. Almost.
Now, when this matter has come up, let's see. Issue notice the process fee is paid. No stay is granted in this.
No, 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 sir.
Yes, what is this?
My lord, sir, I am for the husband, my lord, sir. 6,000 each has been awarded. For the wife, 6,000.
12,000.
12,000.
What is your income?
My lord's income, I have shown 15,000, my lords, which they are not considered. I mean, even she is working, my lords, she is also working on contract basis in Discom.
50% deposit.
Yes,
Then counsel the petition submits that the court without considering the evidence on record had granted an amount of rupees 12,000, that is 6,000 each to the child and to the wife. Considering the submission of the land counsel, they should stay of all further proceeding pursuant to the order dated so and so on the condition that they shall continue to pay an amount of rupees 6,000 by 5th of every succeeding month and shall deposit 50% of the the arrears at 66% from the date of order till today within a period of 8 weeks within 8 weeks from the date of receipt of the copy of the order, same default order.
please.
And then counsel submits that he has already paid the process. Please read his directed to issue notice for response. Yes, next.
Seal number 20. Seal number 29.
My lord, I undertake to file wakaf for the exercise with first matter, you know, and I will take notice in the connected matter.
No. Who is Prasad Patil?
So,
Yes,
is he
given
one
up.
of-
No, that first that retirement memo has to be allowed.
Yes.
That MMO is fine. Retire. Seeking permission to retire from the case. Then counsel, what's your name?
Srinivas Nanamani.
Take that. So and so submits that, gets instructions to file wakalat, delete the name of so and so, and print the name of so and so. Here in 29.1, it also submitted that he has instructions to file wakalat on behalf of the respondents. Ministry is directed to print the name of so and so. List this matter. 24. List this matter on Saturday.
23rd.
Next.
Seal number 30. Statement.
Yes. No representation for dismissal tomorrow. Yes, next.
Hearing on minus, seal number 31.
Notice to the respondents, please read directed to issue notice. Yes, next.
Seal number 32. Nagaraj Cheppano.
Arrears of maintenance wage also, 2,50,000. In that 50,000 put a copy put it there. I will receive the copy, my lord. I will verify. I will submit.
I think last occasion you were saying that nothing is.
Yes, put it that we put it there.
Yes,
Yes, now I
please,
wrote my lord.
Land Council, a memo is filed stating that, a memo is filed that, showing that he has paid, an amount of rupees 2,50,000.
Yes, ma'am.
To the respondent, the Land Council appearing for the respondent submits that, he'll get instructions in that regard. This is matter on Saturday.
Okay, sir. Okay, sir. Second.
Yes. Yes, next.
Seal number 33. Shane Party.
Into dismiss of non-prosecution for non-compliance of the office of veterans.
You are compliant.
Compliant.
Where is the government, this is an excise matter.
Excise.
Where is he? Paso? Yes, next.
33 Paso.
Yes.
Seal number 34.
For complete copies of the reports of the day.
The council submits that. Then what about, maintainability of the petition?
I will submit on maintain letters because plaint was rejected.
Then now our CRP is maintainable.
It's not an appeal CRP.
And that's what I'm saying. If
CRP
the plaint is rejected, you have to file an appeal.
rejected by dismissing the application to condone the deed. It was returned as the new court was established in Angola. It was returned. There was delay in representing the plaint to the jurisdiction. So along with the plaint, I have filed an application. That application is completed. That order is on application and not on the.
It's not an order 7 rule 11 petition.
Application.
The land council submits that during the course of the day comply with the office objections. The office objections are complied with. List this matter for revision on Saturday.
Monday.
Yes.
Seal number 35.
For this, no representation.
35.
Yes. Next.
Seal number 36. Contestation payable.
No representation for dismissal tomorrow. Yes, next.
Seal number 37. Petition Party.
Yes.
In respect of the calculation,
Yes.
just pass on calculation memo, the lawsuit permission manual. This is regarding the payment of the compensation amount to lawsuit. At the first instance, on the basis of their memo, order has been passed. After 3 months, and they filed a review petition before the very same court, and it has been set aside, and as if that they have paid a excess amount to me. Earlier they said I am entitled for more than 25 lakhs. At the first instance, filed by the memo by themselves. Subsequently, I has been filed for review of that order, and the order has been reviewed. Against that, I before this order.
What
Only on the basis of memo
what
of
is the
calculation.
difference of
I
calculation?
am entitled for more than 33 lakhs as on today. They say that they have paid excess about 5,000 rupees.
No, it's not about as on today.
As on.
It's about as on that day.
As on that, as per their own application, that memo.
Let's see the order once.
Yes, yours.
Where is
It starts from page 39, yours.
Oh.
Reason starts from page 41, yours. And then
No, what is the amount as per
amount
the?
is around 30 lakhs 52,775.
Huh?
30 lakhs 52,775. as per their own memo.
Not their memo.
No,
Where is you are referring to something about the High Court order?
High Court order, yes, sir.
Where is that order of the High Court?
In page 137, Your Worship.
137 or 228?
No, first subsequent orders, Your Worship, that in page 137 is reported judgment.
9th April
Yes, sir.
2021.
On this basis, the amount has been calculated at the first instance by the authorities. And they come to the conclusion that what I am entitled for 30 lakhs 52,000.
1 minute.
Yes, sir. In page 42.
Where is the operative portion of that order, High Court order?
Your Worship, in page 152. It's up from page 151.
It is not quantified.
No, not to quantify. That's what it was sent back to the executive court.
Finding in court of the executive court,
Yes,
the
sir.
subject order is erroneous. The petitions are entitled to interest, Land Acquisition Act, or the corporate or solution.
Yes, sir.
So it's only on that aspect.
That's what it was.
Whether you are entitled
in page
for
42 can be seen. In page 42.
42.
Yes, sir. Calculation filed by both the parties. This court passed an order on 25 to 2020.
Let's come to para number 13. Total extent of the land.
Total extent is 12 acres 34 gutas. Your Worship. The preliminary notification is 1975. Till I get the amount in my hand, they are liable to pay the interest.
No, let's see. Total extent of land,
12 acres 34 gutas.
514 guntas.
514 gutas.
Is 41,000
41,000 per acre.
So there is no dispute as far as this
No,
is
not
concerned.
about this. Only regarding calculation. That's what I given a calculation memo today. Sorry, Your Worship.
No, before that, where is the court's calculation? Trial court's calculation. Let's please come to page number 50.
50, yes, Your Worship.
49.
49, it starts from page. Award is 45 acres.
Where is that memo?
Sorry.
Take that photo.
Sorry.
You gave it to him?
Yes, sir. Just not.
So we go by one component after the other.
Yes, sir.
No, code rupees 45,000 per acre.
Per acre. It comes to 5,78,000.
There is no dispute on that.
No dispute.
Yes.
Solution also no dispute.
Yes.
And the additional market value was from 1975 to 77. From the date of disposition or the award which is earlier you were
That is also no dispute.
Not this. That's I meant total is 8,93,546. On that 9% interest for 1 year. 80,490.
No. Where is that?
Sorry.
Serial number 3. I am looking at the court's order.
Sorry. Court order says 41,893.
No. Here number 1 is the serial number 1.
Yes.
At page number 49.
Yes, sir.
5,78,250, no dispute.
No dispute.
Next solution, 1,73,475,
No
no
dispute.
dispute. Then 12% additional market value?
1 lakh, no dispute.
No dispute. Then
Amount
total enhanced compensation?
It was 8,93,540. No dispute.
Then
And in respect of serial number 5 and 6 also no dispute.
5 and 6, no dispute.
Dispute.
Then where is the dispute?
It was para number 8, serial number 8.
8.
Then it starts. Total amount you see that it comes around 24,92,000 as far as my calculation is concerned. That is their calculation. On this you also that I am just calculating because of 8,93,000 was the original award amount. 24 lakh is your interest. On that it comes to 33,86,000. Amount is paid as on 1996, 19,96,762. Total your also that minus it. It comes to 4,95,460.
No.
Sorry.
From here you tell the court, not from your calculation. where did the court went wrong? That particular calculation you show and tell the court. No, we are looking at all the components. You said nothing wrong with 1, 2, 3,
3
4.
to 6 up to 6 days.
What is wrong? Where is wrong? From 7
Afterwards,
days.
the interest is not good. That's my contention.
Where, on which you have to have the interest?
From your worship that is.
I'm looking at 49, page number 49 of the issued order.
I just prepare.
Please do it. What I want is.
Sorry.
No, it's okay. Go from, we have
Yes, yes.
what you do is.
Tabular form. Yes.
What you can do is, or you can tell the court, like 49, 50, 51 are the calculations. What is right, what is wrong? If it is wrong, how it is?
Yes. 26 or 28.
This is matter of 28. By the time the petition shall file a calculation now. Yes. Next.
Bill number 38. Another sticker, bill number 38.
Let's seek for weeks time, let's
Time report order. Yes, next 39.
please.
Bill number 39. Sridhar Veeraman.
No representation for dismissal. Next 40.
Bill number 40.
That's 2 days time for.
40.
2 days time is granted default order. Yes, next 41.
Bill number 41. Vasangowda T.
No representation for dismissal. Tomorrow. Yes, 42.
Bill number 42. Amrut Vasan Joyce.
Same order. No representation. 42.
Please take the orders, IE orders.
It's 2 minutes.
Orders and IE orders.
But they don't know that it will be called, so we'll go in order. Yes.
Signature matters, bill number 44 urgent.
No, 43 you are not called. 43 you are here.
This is a petition filed by the husband, asserting the order passed by the family court wherein 10,000 maintenance has been awarded to the respondent.
What is your income?
My lord, we dispute the marriage itself because the present petitioner is married with some other lady and she is 70.
What is the finding of the court on that?
Finding of the court are that the viewing the photographs and other things, the family court comes to the conclusion that there is a marriage.
Because under 125, the court will only look at all the. It's not a full-fledged trial.
My lord, my submission is when she has not disputed my earlier marriage.
Huh?
First marriage she has not at all disputed. Because
Let's see that. Let's see
if my
that.
lord will peruse if page number 45, that is para number 10 of the family court petitioner. The petitioner, in order to prove her claims, has referred as PW1 while affidavit by tracking the petition over note and produced the documents at exhibit 12 to 24. The learned counsel for the respondent has passed PW1 at length in such of her cross-examination of PW1 has stated the date of marriage wrongly as 39/2000, though it is cleared 31/8/2015 in the petition. In her further cross-examination
It is in her further cross-examination conducted by the counsel for the respondent. She clearly suggested that taking the disadvantage of weakness of bringing all four of the respondent, the petitioner and the father got married and created the photo. Such session of the counsel of the respondent would reveal the solemnization of the marriage is admitted. But according to the respondent, when he was in a drunken condition, the marriage was performed. So, in a way, you are admitting the marriage and you say that it is done.
But in the further manner, PW1 has expressed their ignorance to suggestion that the respondent married one puja on 10/6/2015 and they have got 2 daughters out of their wedlock. PW1 has also expressed the respondent promised her that he would take her to Assam on service and at that place he would get her Aadhaar card as identification of her his wife, and thereafter at the present she has no Aadhaar card to show that her identity as a wife of his father. My lord, my submission is as per section 125, legally vetted wife is entitled.
Where is the evidence that she is not a legally aided
My
wife?
lord, we have denied even in
In all the marriage photographs, you, your parents, everybody are seen in the
No,
photos
that photographs we have,
created.
we have distributed. Seriously.
But then you're disputed still under 125, all these things cannot be. If you say that she is not legally wedded by, take your course of action. Whatever that prima facie evidence that is available on record clearly shows the relationship.
He is serving in army, madam.
Huh?
The petitioner is serving in army.
Serving in army.
And he is getting 60,000 rupees salary. Out of that,
Court has granted how much?
10,000.
10,000.
10,000. It is also.
If the calculation of Neha and that Rajesh versus Neha has to be taken, it would be more.
Malak, my submission is when she pleads ignorance about first marriage, Malak,
What is wrong? She doesn't know that
she is not a legally wedded wife itself.
Where is your evidence to show that you are already married and you have a first wife? And what is the evidence that you have accused? Let's see. What are the exhibits?
Malak, R1, that is the marriage idea of the first marriage.
So your assertion is what are the they are marked on your behalf?
Exhibit R1.
What is the exhibit of
That is the marriage idea.
means?
Means marriage, before marriage, all the elders will do one ceremony called marriage idea. Wherein for that only they will do the marriage and subsequent.
No, you have a first wife.
Yes, ma'am.
And there is a legally subsistence, that is in subsistence. Can't you examine her? If that's the case.
Malak, because of his serving in army, he did not get the sufficient time to.
No, please don't tell all that. Please come. Agreed with orders passed in Criminal Miscellaneous number 46 of 2020, dated 12th July 2024. The husband is before this court. The respondent herein had filed the petition seeking an amount of rupees 20,000 per month as maintenance. It is a case that she is a legally wedded wife of the petition herein, and their marriage was formalized on 31/8/2018 as per the Hindu rites and customs, and they do not have children in the wedlock. And the respondent is working in the army. She has made several allegations on the husband and how she was made to leave the matrimonial home, and also that she is not able to maintain herself. According to her, the salary of the husband is 60,000 and he owns agriculture lands, and to that there is income of 2 lakhs per annum. Such an amount of rupees 20,000 may be granted towards maintenance. The petition herein, who is the respondent therein, had denied all the allegations and also has denied the fact that the petitioner is the respondent herein is his wife. According to him, he is married to one Pooja Sanjay Kamble on 16/10/2015, and in the wedlock they are blessed with 2 daughters, and he has been residing with his wife, children and parents happily. And according to him, the respondent herein is not the wife. It is only with an intention to harass him the present petition is filed. On behalf of the wife, exhibit P12, P4 were marked, and she examined herself as PW1. On behalf of the husband, RW1, he examined himself as RW1, and a copy of marriage YWADI is marked as exhibit R1. The family court had considered the evidence adduced on behalf of both the parties, particularly the wedding card, the photographs, which shows that the petitioner as well as his parents are seen in those photographs. And further, a suggestion was given to the wife stating that the husband, while he was in an intoxicated state, the marriage was performed, and the court, and even its evidence of argument, that is the husband, that while he was in an intoxicated state of drunken condition, the marriage has taken place. The court has come to the conclusion that itself shows that the husband is accepting that the marriage has taken place. And further, the proceedings under 125 CRPC are in summary in nature, and basing on the evidence that is placed before the court prima facie, the court has come to the conclusion that there is the respondent herein is a legally vetted wife of the petitioner. Further, considering that he is working and earning salary of 60,000, the court had granted 10,000 maintenance. Next paragraph. Agreed thereby, the husband is before this court. Let counsel for the husband submits that he is as per section 125 CRPC, only a wife or a divorced wife is entitled for maintenance. According to him, he is already married, he is already having a wife and children, and she is not a legally wedded wife, and in that view of the matter, she is not entitled for maintenance. It is further submitted that she pleaded ignorance of the first marriage. All these aspects were not considered by the court and granted maintenance of rupees 10,000. Even otherwise, the amount of rupees 10,000 that is granted to the court is on the higher side. Anything else? Having got the land counsel for the petitioner, there is a material on record. This is a petition filed by the wife under 125 CRPC seeking maintenance. In support of her case that she is a legally wedded wife, she has placed the evidence. As per the husband petitioner, she is not the legally wedded wife, and he has filed some exhibit R1 that he is married to someone else, and the respondent herein is not his wife. It is his case that the first he has married another lady, and in the marriage they are blessed with 2 children. Nothing has stopped him from adducing the evidence. Even in the photographs, even to deny the photographs, it's not that only some wife and the both petitioner and respondent are shown in that, but in fact the entire family is present. And the suggestion that is given to the wife also basing on the suggestion that is given to the wife also shows that the husband is accepting the marriage. The trial court, the family court, basing on the evidence placed before it and considering the same, had rightly come to the conclusion that the respondent is a legally wedded wife of the petitioner, and the proceedings are summary in nature. In that nature, further coming to the aspect of maintenance, when the husband is drawing 60,000, court had only granted 10,000. Even on that count also, this court do not find any reasons to interfere. Accordingly dismissed.
If a weak adjournment motion, release the memo of calculation. The last occasion.
All finding a memo for having served copy of the petition on the council. Somebody is appearing. No, so nobody is appearing. R1 and R3 served, that's what it shows.
The last occasion of the the council directed me to produce the memo of calculation on behalf of the company. If a weak accommodation
But it should have done it. How many times the matters will be listed and lectured? This is matter on 28, 29, no further adjournment. At the request of blood counsel the petitioner. If it is an interim order is there, look at it and extend. Yes, next.
Number 46, subjects, number 47. Murad R. Kulkarni. Let's pull up.
Husband petition, that's 5,000.
5,000 is the order. What is your income?
Income only, he was having only 2 acres of land, but they have taken their 20 acres of land, they are not.
So how much your, what is the income deriving?
I am fully working, I have only 2 acres of land, it is in the name of the father, we have 2 brothers. It is not in it, but they have taken their 20 acres, but they are not ready to document, expert of 3,000, now it is reminded to 3,500. I have deposited 3,500 to put the trial court. But the trial court is dismissed for non-prosecution, that's why I am not reserved. Last occasion was on 31/8, I deposited 20,000.
No, it is dismissed for non-prosecution, your petition. So what is to be done?
Yes, sir.
Is the RPFC, what is the dismissed for your execution petition?
Yes, because it has been dismissed for non-prosecution. In that, he has deposited 79,000, there is no issue at all. And in the last date of listening, he has paid me 20,000. So, for the petition is concerned, the trial court has ordered for 5,000 rupees by ex parte. Right now, the scenario is like that, as his contention is entirely
No,
based.
how can, you can't even pay 5,000?
3,500.
Huh?
Because they are not expert, they are not ready to give document. I have only 2 acres of land, he was a fully working.
Now, what can be done here?
Yes, please.
The order can be set aside and remanded.
Please,
Unnecessarily,
please.
Yes.
unnecessarily another round of litigation for your client.
Yes,
He says he's ready to pay 3,500.
yes.
If it is acceptable to your client,
But
will
one
pass
more
an order.
information, in the last date of proceedings, in the predecessor of his honorable lordship has made over the matter like amicable settlement. One version was like that 5 lakh paid. Another version was like that 2 lakh. Another version like 50,000. Is it nothing but a bargain?
What is the present version?
It is nothing but a bargain.
They are not.
Huh?
The present response is not present before the mediation.
Why?
Yes, this version is entirely one thing my person is here. The version is like that when we put for the proposal, we should track it. So it is their version. So my person, let the senior come before this and put 1 week short of it. Senior is engaged in a special matter.
Why don't you
One-
come
one
out
week.
with some,
Maybe reminder version, we will give us opportunity to the.
no, let's not do this exercise. Please tell the court what is the amount you are ready to pay as a one-time settlement. Next weekend, no mediation, let it be before
Yes,
this court.
please.
But the next week, if the counsel for the respondent submits that the wife is ready for a one-time settlement, then counsel for the petitioner husband should come up with the amount which the husband is ready to pay towards one-time settlement. This is matter on 9th December.
But please, yes, yes.
Yes. Next.
Bill number 14, article something medium, Lorada Deshpande.
After getting this honorable court and directed him to file an affidavit to the effect that the 3 children are staying with the petitioner. Affidavit will tally with the.
Give her a copy of
Please
it.
do this.
Yes, list is covered after tomorrow, go through that. Yeah, let
I'll
council,
send you the
as per the orders passed by this court, let council submits that, he'll be filing the memo, he's going to file the affidavit today. This is
Along with
matter,
the school fees and.
along with the school fees and other details, this is matter day after tomorrow. It is submitted and he has already served the copy of the council for the response. Yes, next.
Bill number 49, Sir Gundappa, please, sir.
On the last occasion, also the respondent has to give a proposal to the petitioner. They have to make submission because
So, proposal given by the respondent, the husband, of the wife and child is that minus, he is ready to give 50% of the out of the eternal benefits. Wherein he.
That's what last.
Yes.
And it was said that 50% it will be given or some, is it the case where the other benefits shall go to, no?
No.
Okay.
50% of the
Very nice.
amount received.
I saw the-
As a full and final settlement.
Only 50% of the eternal benefits, that's what the husband has given the proposal. Wherein my party instructed me, this is the information furnished by my party. Only 50% of the eternal benefit plus 50% of the pension amount. And by entering their name in the pension. Wife and child. So child is now, she is studying in first year degree.
No, you're asking something
Please, madam.
more than what is granted granted by the trial court. Compromise is not something you will get it.
Yes, absolutely,
More than
madam.
what is granted by
Plus,
the trial court.
we are two in numbers, so that how to live in this.
Now, what is the maintenance that is granted?
5,000 may not, sir.
When
2,000
the
to
court,
wife.
no, when the court grants 5,000 and your client asks 50% of pensionary benefits, 50% of terminal benefits, 50% of
Now
everything.
we are ready to go and join with the husband, but
She left the company to petition 20 years back, 25 years back, well, and now he is physically handicapped person. He can't stand himself for throughout his life. He needed maid throughout his life. She left the company nearly 25 years
No,
back.
she says that she'll join.
Please,
She says that she'll join with him.
but he told that she left the company 25 years back. Now she's only joining because of money. She has
No,
loan.
not because of money.
He told what he submitted
I
as
find that daughter is studying in a first year degree.
Ask him, is he ready to take?
Actually, some company one time settlement is ready. He told me.
Tell her
Please,
the court will not grant what all she wants, even though an enhancement is also there.
please.
It won't be like what she'll be getting of that 50. What is the 50% of the terminal benefits?
It will come to 5,90,000.
So, for example, this 5,000, if that's what remains to be, per year it would be 60,000. It would be 60,000.
Please.
So, like, when till what time you'll get what it is, you don't know.
It is one more submission. The petition aspirant is put for declaration before the trial court to declare that she is entitled for 50% of the whatever in pension and gratuity and PF. And the suit is also pending for consideration.
She left him 25 years back.
No. Yes, gone out way from the.
Whatever it is, thrown out or left, but they're staying separately for 25 years.
7 years. Not
Huh?
7 years.
20 years and 50%.
Now, what about the no divorce, nothing?
Yes, sir.
Still, he is in arrears of 60,000.
Also, they have filed one recovery petition and the state recovery petition interim is paid. They have to file one more recovery petition.
Every month,
They
every year.
have to file a recovery petition. Whatever they filed recovery petition in the state petition, he cleared all arrears.
No.
No. Please tell your client.
Please.
No, this is not going to be, this 5,000 is not going to be increased. If she's okay with it, 5,000, what is granted by the court below, will not be.
Not keeping them.
No, what is his age? What is, how can
But he is getting 27,000 pension per month.
Let her think about the settlement once again and come back. We'll pass order on the merit of it if it's not working out. But definitely it will not be like how she wants. She has to think about it and come back.
That's then it may take up some other day.
We will take it some other day.
Please.
And he doesn't have to come to the court, you can get instructions.
Please.
This is matter on 12th of December. By the time the counsel appearing to the petitioner shall get specific instructions with regard to the settlement.
Please,
Proposals
please.
made by the respondent. Yes. Next.
Number 8 part. Settlement.
Pass over.
Number 51, 52, number 50.
But the judgment was registered on 7/11/2024. It's not about the directive for the petition in second petition to serve copy.
He didn't serve.
No, the yesterday evening not served copy.
Okay, we'll
After
take some
that,
other
2 weeks
day.
time to file objection. Second.
Why in the CP for 2 weeks for objections?
No.
We'll have it on
Yesterday served copy, madam.
28th we'll have.
29.
29th. This is matter on 29th. Simple matter, CP. Why you require such much time?
Allah, but yeah, more than 15 days, madam, we served yesterday.
Actually, why were you taking this much
Seek
time?
apology or
Land counsel for the petitioner submits that the respondent has filed his objection. To file his rejoinder to that, he requires a week's time. Mrs. Martin on 28th. You have the papers in the other matter? Yes.
29.
29.
Interior model.
Inter-alia earlier granted is in the, I think in the first matter, is extended to the next date of hearing. Yes, next.
Till number 54, number 8 part, number 3 part,
No representation for the respondent. Counsel the petition is present. Mrs. Martin on 27.
27.
Yes, 55.
Till number 55, where Prima Guru Sappa Hoga,
Connected matter, matter for petitioner matters, for wife matters.
Where is the other side?
Contact is file.
Vijay Krishna,
What is your name?
Neelam Reddy Gule and Anmesh Sandesh.
In 55, RPFC 1002160 of 2023. No representation for the petitioner. Counsel for the respondent is present. List RPFC 1002160 of 2023 for dismissal tomorrow.
Meantime, latest salary certificate may be directly produced.
To whom? We should be here to pass an order. Let him come tomorrow.
Please.
till number 56, Jay Shetty,
Last week directed to produce translated copies of Kannada version, my lord. Half of the documents completed. 2 days time we can give.
Saturday.
Please.
This is matter on Saturday.
Monday.
23rd,
Monday.
This is matter on 26.
Please.
At the request of the counsel, the petitioner for filing a translated copy. Yes.
till number 57,
Interim.
Inter-alia earlier granted is extended. Yes, next.
57, Ananda Kumar Sekhar, duty respondent number 1,
No representation for dismissal tomorrow. Yes, next.
till number 58, Budenata, Lakshmikant Reddy,
Inter-alia is there. Where is the counsel for the respondent? Password? Password.
till number 59, Grishas Philemon, Rejection Kulkarni,
Revision petition challenging the order of rejection of the application filed under order 7/11 minutes.
What is the suit for?
Minutes, the suit is filed by the respondent number 1 minutes for the permanent injection minutes. Wherein minutes, the defined respondent number 2 herein has availed the loan minutes by the petitioner bank.
Oh, it is filed by the bank.
Petition is by the bank minutes. Suit is filed by the one of the minor claiming to be the owner of the suit scheduled property which has been mortgaged in favor of the bank.
Surface proceedings are initiated.
Initiated minutes. Thereafter minutes they had filed a suit. Wherein minutes I may be permitted lordships to take to the
So what is the order of it? Please come to the order. First, let's see the
order minutes at connection E minutes page number 36.
page number 36.
36 minutes. The application came to be filed by the petitioner bank under order 7/1, stating that the bank has initiated recovery proceedings. As such, the suit filed by the respondent number 1 is not maintainable.
Now, Lords, that I can be rejected. The reasoning, if your Lordship may kindly see the page number 42 below, second paragraph. In this case, the plaintiff is not the borrower of the bank. He is the joint owner of the suit property along with his uncle. The suit property is secured to the bank for the loan obtained by his uncle.
So, no, it is like it's all collusion between the parties. The same thing, you can go before the tribunal and say that this was.
No, Lords, I am not the borrower, Lords.
Your property, once the surface proceedings are initiated, whatever it is, why can't you go before there are all these tribunals are particularly constituted for this purpose. The relief, what you want and what you're seeking from the civil court, why can't you go before the very same tribunal and say that it's my property?
Lord, sir, civil court jurisdiction is not barred by the, I am not a party to the loan agreement, I am not the party, I am not a borrower, I am not a surety.
When the surface proceedings are already initiated, when you can have a remedy, why should you invoke the remedy of the civil court?
Lords, because I'm not party to the DRT proceedings. or anything.
Your property is a party.
My
Your
property
property is part of the proceedings.
Please, no.
So you can tell the DRT as well.
My lords, one important fact, my lords. My lords, the uncle of the plaintiff was filed a suit, my lords. My lords, he has submitted an agreement of sale, wherein he claims that, my lords, he is going to purchase in the individual capacity, my lords, as per the agreement of sale. And on the basis of the agreement of sale, my lords, the loan came to be sanctioned. And thereafter, my lords, at the time of execution of the sale deed,
He was also made that person as a party.
please, my lords, the
As one of
plaintiff
the
was
co-owner.
included as one of the
Co-owner.
co-owner, which was not as per the terms of the sanction letter by the.
In a way, it is defeating the very proceedings.
Lords, the only ground we are.
You purchase the property, property was purchased after the loan is obtained.
Please, Lords, I am not a party to the agreement, Lords,
And you became a owner to the property.
only to the extent of I gave my portion of the.
Now, is it the fact that by virtue of the loan that is granted, that property came to be purchased?
Purchase.
No, for purchasing the property, a minor can be, the property can be in his name. Now, once he is defaulted in paying the amounts, when the surface proceedings are initiated, now you say that I am a minor, my property, I don't have nothing, I am not a borrower, then how come the property, or did you purchase the property?
My Lords, we purchased property, I paid my portion of the payment to the purchase of this property, Lords.
Where from? You're the minor.
Please, Lord, sir. My guardian, she paid. My guardian is my mother-in-law, and she, along with my father's money, we have paid for the purchase of this property. Loan is taken by the other person, Lord.
That will be decided by the court, but by the tribunal with regard to that property. You are not about the same thing. Why cannot please tell the court? Why, when the already surface proceedings are initiated, why not? Is it that you have no remedy?
Lords,
So first you answer to that. You don't have a remedy. Then we will go. That though you have a remedy, you can't. You can as well go before. That's a different aspect. I'm just asking you, what all you are raised before the civil court, can't it be raised by you before where the proceedings are pending?
Because Surface Act only deals with the loan and the borrower, Lords. I'm not the borrower here. So
So a third party can't go to the recovery the tribunal.
Lord, sir, I'm not a party to the Surface Act proceedings which are taking place, Lords.
No, it is
And
not
so-
like that. Property to be taken out of surface proceedings and parties to be taken out of. It's not that. It is a transaction. Is one and the same. Basing on that amount that's granted, a property is purchased, and everything is pending before the tribunal. It would be easy for the tribunal to decide. Here, there is no question of fraud. There is no question of other things where the civil court will invoke the jurisdiction.
Lord, sir, my only contention is that I am not a party to the Surface
That you have said. I'll record that submission.
and I'm neither a borrower or not a party to the loan agreement, Lord. Now, Surface Act does not,
When the property is
exclude.
mortgaged, then you are aware of all that.
No, Lord, so like I thought that only is part of the.
Then that you will be telling the court, the tribunal, you will be telling that this is how it has happened. For that, why should you go to the civil court? What is this suit for injunction?
Please, Lord.
Uh,
Because my
By virtue of the
property-
mortgage that is entered into between you and the bank. Now,
Not between me and the bank, Lord. My uncle, he is between he and the bank. They are the parties.
if you want time, we'll grant a day's time.
Please
But
each time, Lord.
this matter as parted on 25th at the request of Land Council for the respondents.
25th, my lords, 26th or
26. heard the counsel in part at the request of the counsel the respondent. This is matter on 26.
Yes.
Yes, next.
Number 60, 61 address, serial number 62. Yes, Kumar. Tell us, please.
Yes.
90 minutes.
It is for declaration and rejection memo. I try to plaintiff. Respondent number 1 memo. Trying to declare that will date of cancellation memo dated 11/11/2020 is not
Binding on.
Yes. The earlier memo defendant number
No, what is the impugned order? First to tell the court.
page number memos 40
Page number
40
40,
14 memo 14.
14.
Yes.
You're the defendant in
Number
this
1
suit.
memo.
You filed this IA
Yes.
under order 7 to 11. Suit is for declaration that the gift deed is not binding on them.
Not 15 memo.
Uh,
Deed of cancellation executed by defendant number 1 memo in favor of defendant number 2. That is not suit is filed by
Please come to the plaintiff. Let me understand what is the relief.
Relief memo
There
page
is a
number
plaint.
Plaint is at page number
page number
19.
24 memo.
So that the deed of cancellation is,
Yes.
what is the original deed?
Originally, defendant number 1 had sold the property to defendant number 2
Uh,
by a registered sale deed. Thereafter, defendant number 2, since he could not bear the expenses, he made a GPA in favor of plaintiff, that is respondent number 1. And that GPA, in that GPA, he mentioned that later to execute the sale deed. Meanwhile, after the GPA sale deed was created,
Who is the owner of the property? Defendant number 1.
please,
Defendant number 1 has executed a sale deed in favor of defendant number 2.
please.
Then
Defendant number 2 has executed a GPA in my favor, that is plaintiff's favor, alleging that after the property has been transferred to his name, I can execute the sale deed in my favor.
Itself executed sale deed memo.
Thereafter, in between, defendant number 1 and defendant number 2 have gotten deed of cancellation, saying that the original sale deed, which defendant number 1 had sold to defendant number 2, is thereby cancelled, thereby affecting my rights.
what is your document? What is the document given in
I
your
registered a GPA in my favor.
what that CPA says?
It says that my GPA is at page number 39.
It's 439. This is our first document is deed of sale. That's made on 4th September 2018. I've seen that. 4th September 2018 is a sale deed. Defendant number 2. Then it's an absolute deed of sale. What is this dated? What is it? Let's see. Paragraph. First is one is with regard to appearance. Next two.
Then paragraph 7.
So, by virtue of this GPA, You were permitted to do certain acts. Hmm.
But it's nowhere in the system that it has to be, that specific clause nowhere that has been mentioned that I cannot receive CD in my favor. They claim that the GPA was made for development of the property.
Because this GPA is a specific, you've been asked to do certain things. As an agent, you will be doing all this.
But they are claiming that the GPA was executed only for development of the property.
Because you are not, there is no possession in this.
We have treated the procedural agreement while executing.
It should contain. This doesn't contain.
But
It is.
we have taken a specific guidance. If the lordship can see the order of high cost by the value. The value is rejected the order of the ground that says basically rejection of the plate is only on the ground of the plate. They are taking guidance that based on their statement, we got the rejected. That is not possible. Because of the register.
No, very strange. What is this suit for? How can you maintain this kind of a suit? How can it be you are not a party to that? You are not a party to that. It is their will and wish. They will do it. Somebody, B has a property. He has appointed you as an agent to take care of it. And from whom he has purchased the property, both of them have no issues to cancel it. And automatically this GPA will go. How can you stop? And it is not even your case that GPA is for a consideration. Where is that? Why will they give consideration when you are only an agent to do things?
So we made a schedule to
Page number?
39.
Not 39. Please refer to the internal pages of that GPA. There are page numbers on the top of that. Every GPA has a page number. Each page has numbers. It runs into 7 pages. It's only permitting you to do certain acts. How will you become the owner of the property? You execute a sale in your favor.
Yes, sir.
In that the schedule of payment has been mentioned. As on the date of executing CPA, if the lordship kindly presents the CPA that page number 37. Sorry, there's no page number here. Page number 39 is the schedule of payment. Which has been made as the date of the.
No, Mr. Counsel. You are having a good case on merits, but now, as of now, looking at the amendments in the plaint, all these things now along with the plaint, all these things are placed before the court. All these documents. Documents are not placed.
That is why the value of contract has been decided to be placed.
You didn't find that all these, your GPA, nothing has been placed along with the plaint. And the court has to necessarily look into all these documents at the threshold. How can it be rejected?
My only contention is no proper cause of action. Cause of action can be seen, my lord. That's page number. Page number 24, my lord.
The cause of action arose on voice
Nothing
of
else
the.
mentioned, my lord.
What is this cause of action?
Paragraph 9, page number 23.
I'm looking at it.
Paragraph 9 here for me.
It's not paragraph 9. Cause of action is paragraph number 5. I think you're having a different file or what? No. When there is a cause of action, the cause of action will be one and the same in any of the papers. Plaint. You have 10 cause of action. Something like from 8, 9 paragraph. Then they give it as 5 cause of action. Cause of action, just read it. The cause for filing the suit arose on. What is the false document?
the cancellation of treatment between different number and different number. Very paragraph 9, paragraph number 9.
No. How can it be that they have executed a document defrauding your interest because of the document? But what is that foisted the false document?
After the cancellation of treatment, they are coming to my property and trying to oust me from the property.
That is not what you stated, so.
Paragraph 9 I stated.
Yes.
Paragraph number 9. The different number 1 that receive the entire sale cancellation amount for sale of two property from him handed over his original identity, handed over actual physical possession of the two property to the plaintiff, and executed judicial power pertaining in his favor.
Please come. Agreed with orders passed in I number 6 in OS number 335 of 2021 dated 4th March 2024. The first defendant or second defendant you are?
Defendant number 1.
Defendant number 1 is before this court. The respondent herein, who is the plaintiff in the suit, had filed the suit seeking the relief, seeking a declaration that the documents filed as deed of cancellation dated 11th November 2020, registered with the sub-registrars Belgavi, is vitiated by fraud, and an order of injunction restraining the defendants from disturbing and obstructing the peaceful possession, use and enjoyment of the plaintiff or the suit property. It's a case of the plaintiff that the defendant number 1 is the owner of the property, and defendant number 1 had executed a sale deed in favor of the defendant number 2, dated
6/9/2018, earlier settlement amount.
6/9
2018.
6/9/2018. Thereafter, the second defendant has executed a GPA in favor of the plaintiff, and the plaintiff, being the GPA, got the sale deed executed in his favor after paying the necessary amounts to the defendant. It is a case of the plaintiff that the defendants 1 and 2 in collusion have executed a cancellation deed, and such a cancellation deed is executed by plain fraud and to defraud the interest of the plaintiff, and as such he has come up with the suit. The defendants have filed the first defendant had filed an application under Order 7, Rule 11. Where is your application?
Along with memo, I have produced.
He has filed
Number 6, page number notes.
what is this counterclaim?
Counterclaim notes alleged the GPA is not binding any memo. It is a claim.
Then the defendant number 2 had filed his written statement and also a counterclaim that the said GPA is not binding on him. No, you. Defendant number 1. Defendant number 1 filed his written statement, has also filed a counterclaim stating that the GPA that is executed by defendant number 2 in favor of the plaintiff is not binding on him, and also he has filed an IA.
Number 6.
IA number 6.
On 16/11/2023.
1 minute. IA number 6 for rejection of the plaintiff.
Page number 60.
Page number
60 memo.
60. Seeking rejection of the plaintiff. According to him, the plaintiff do not disclose the cause of action. It is the case of the plaintiff, the defendant number 1, that the plaintiff, though he has no right and title of the property, had come up with such a vicious suit without a cause of action. And the cause of action that is pleaded by the plaintiff is baseless, deceptive, and misleading. Hence, the plaintiff is rejected. The trial court, by order impugned, had rejected the said application filed by the plaintiff. While rejecting the application, the court has considered the scope of Order 7, Rule 11, and the judgments in that regard, and observes that The plaintiff has seriously disputed the deed of cancellation executed by defendant number 1 in favor of defendant number 2. The defendant number 2, having disputed the execution of the cancellation deed, has not filed the written statement.
Yes, filed notice.
That's what is
Now,
recorded.
yes.
2.
Now he has filed.
That time they were.
That time not.
Instead, only the defendant number 1 had filed his written statement by way of counterclaim, that too after the plaintiff led his evidence. The court comes to the conclusion that without full-fledged trial and recording evidence, the court cannot decide whether the suit has a cause of action. It's a matter which requires to be considered by the court by appreciating the evidence of both the parties. The plain reading of the plaint at this stage do not indicate that the plaintiff is liable to be rejected and the suit is not maintainable. Hence, the application was rejected. Agreed thereby, the plaintiff is before this court. Learned counsel appearing for the agreed thereby, the defendant is before defendant number 1 is before this court. Learned counsel appearing for the defendant number 1 has drawn the attention of the court to the cause of action, and basing on that, he submits that the plaint do not contain the cause of action, and on that ground, the plaint ought to have been rejected. It is submitted that the court had failed to consider the contentions that are put forth by the defendant in his proper perspective and has dismissed the application. It is submitted that the GPA has no right to say that the cancellation to the said deed when defendant number 1 and 2 are the parties, and they have every right to execute a cancellation deed, and that cannot be questioned. He submits that the court giving such a rejecting the application expert. Learned counsel appearing for the plaintiff submits that he paid the consideration and
Not received consideration.
not you, he is from defendant number 2.
Yes.
He submits that he has paid the consideration to defendant number 2, and after taking the consideration, and he has executed a revocable GPA, and basing on the GPA, the sale deed is got executed in his name, and in the sale deed, the particulars of the payment that are paid by the plaintiff are mentioned in the said sale deed. It is only it's a collusion between the defendant number 1 and defendant number 2. They have come up. The cancellation deed has been executed. It is submitted that in the plaint is it's a bundle of facts, and the court, while considering while considering what is a cause of action, not only from that, it has to look at the entire abundance, and the abundance clearly discloses that there is a cause of action for the plaintiff to file the suit, and the court had rightly considered all these aspects and dismissed the petition. Expert. Having heard the counsels on either side, there is a material on record. The suit is filed seeking a declaration that the cancellation deed that is executed between defendant number 1, defendant number 2 is not binding on the plaintiff. Defendant number 1 executed a sale deed in favor of defendant number 2, and in turn, defendant number 2 has executed a GPA in favor of the plaintiff, and the plaintiff got executed a sale deed in his favor. Now, the plaintiff, being a beneficiary of the transaction between the defendant number 1 and defendant number 2, according to him, having taken the entire consideration by D2, D2 cannot execute their cancellation deed. Not to sale consideration to defendant number 1. So what did you write?
According to the statement, execution by
the defendant number one, and now only for causing loss to the plaintiff, the suit is filed. And he submits that all these aspects are beyond the scope of an application filed at order 7 to 11. And all these aspects, as rightly held by the court, cannot be decided at the threshold. Somebody, what did they say?
scope of application
No,
filed at
not
order
as
7.
contention. It is in a discussion, no? The discussion, what is? So, just read from the one. Have you heard the counsel summary this said?
The suit is filed seeking declaration that the cancellation date that is executed between defendant number 1 and number 2 is not binding on the plaintiff. Defendant number 1 executed same date in favor of defendant number 2 and defendant number 2 has executed GPA in favor of plaintiff and plaintiff go executed sale deed in his favor. Now plaintiff being beneficiary of the transaction between defendant number 1 and 2 according to him taken in their consideration by defendant number 1. And now only
The intention to cause loss to the
plaintiff.
the suit is filed.
And he submits that all the substance
That is it. That substance is not it. When an application is filed under order 7 to 11, the scope of inquiry is very limited. The defendant has to demonstrate before the court that looking at the plaint developments, the plaint has to be rejected and it falls under the categories as enumerated under order 7, rule A to D. In this case, even to consider all these aspects, court has to look at the safety, the GPA, and the further safety, great safety executed in favor of the plaintiffs, and looking at the plaint developments alone, at this stage, the court cannot reject the plaint as the plaint do disclose the cause of action. All the grounds that were raised by the plaintiff, the defendant number 1, can also be raised in the course of the trial, where the parties will get an opportunity to adduce evidence and put forth their case. This is not a case where the plaint can be rejected at the threshold. In that view of the matter, this court finds no reasons favor. Accordingly dismissed. Yes, sir.
Seal number 60. Insane.
The suit for partition is filed by the plaintiff number 1 to 3 and against the defendant.
What is the application?
Application number 7 to 11 application filed by the.
You are the defendant number?
Defendant number 2.
You are the member of the joint family?
No.
Or a purchaser?
I am the finance institution, Your Lordship. The plaintiff number 3 and defendant number 1 has approached the financier, the defendant number 2 and taken the loan from the defendant number 2. Your Lordship. As per the and we are granted the loan to the plaintiff number 4 and defendant number 2, defendant number 1. Your Lordship. And after Your Lordship, the loan is NPA upon Your Lordship, and they issued the proceedings as initiated under the Surface Act. And in view of the order of the trial court, we have taken the symbol of the position. After taking the position, they have filed the suit for partition against the defendant number 1 and 2. Defendant number 1 and all the plaintiffs are colluding with each other.
No. Defendant number 1. What is the relation between the plaintiffs and the defendant?
Plaintiff number 1 and 2, father is the defendant number 1, right? Plaintiff number 3, husband is the defendant number 1.
So, wife and children have filed a suit against the father.
Father
for partition.
For partition, along with the finance institution. Here, the wife is the co-borrower.
When were the surface proceedings concluded?
Surface proceedings concluded in the month of January of 2023. Afterwards, they have filed the suit.
So what has happened? You have sold the property.
No, no, they have taken the position. After taking the position, they are trying to super partition. Now we are trying the application 7 to 11 your lordship. That with 34 of the Success Act your lordship, court is not.
Please come. The defendant financial institution is before this court. I believe with the orders passed in number 2, in OS number 9 of 2023, whereby the application filed by them seeking rejection of the plaint is rejected by the trial court. It is submitted with the legal counsel that the defendant number 1 has availed the loan, and the plaintiff number 3 is also plaintiff number 4 is also a co-borrower. And as the court has become an NPA, they have initiated the proceedings under the Self-Help Act, and the position was also taken by the bank. At that point of time, this suit came to be filed, which is a collusive suit, considering the submission of the legal counsel for the petition. Collusive suit, and the trial court had failed to appreciate the contentions put forth by the financial institution. Considering the submission of the legal counsel, they shall stay a fall for the proceedings. In OS number 9 of 2023, dated in OS number 9 of 2023 till the next date of year. Petition is permitted to take court to have summons on the counsel appearing for the respondents and shall file a memo to that effect. In addition, the registry shall also issue notice.
Number 64. Followed by the part.
Yes. Take that. Yes, seeking from transfer where to where?
From Hubballi to Bukiri.
What's the distance?
150 kilometers.
And what about when is the MC filed?
Hello. MC petition of
24.
Yes, madam. 24.
Where are your objections? Take that. Petitions for the?
Father of the petitioner is a retired police officer, madam, but he is paralyzed, madam. He is taking neurologist treatment, madam. So I will submit the document, madam.
The present petition is filed, seeking transfer of MC number 344 of 2024, pending on the file the principal family court, Hubli, to the family court of Hukari. The facts of the case are like this. Fact of the case are, the marriage was solemnized on 28/4/2019 at Hubli. In view of the differences between the parties, the wife is staying at Hubli. Wife is staying at Hukari. Yeah, wife is staying at Hukari. Hukari. And as she is not able to maintain herself, she has filed criminal miscellaneous 78 of 2021, seeking maintenance on the file of the courts at Hukari. Later, the husband had filed MC number 344 of 2024, seeking MC number? He has filed MC number 78 of 2022, seeking restitution of conjugal rights. It's decreed. It was referred to Mukherjee, and the matter was referred to mediation. As a mediation, the wife was not interested to stay with the husband, to join the husband. The husband had filed MC number, he withdrawn the same and filed MC number 344 of 2024, seeking divorce on the file of the family court Hubli. Now the present petition is filed with the wife seeking transfer of the said pending MC from Hubli to Hukari. Let counsel appearing for the husband submits, wife submits that the distance between both the places is 150 kilometers, and she is depending, her father, who is a police officer, is a paralytic patient, and she cannot travel on each date of hearing all the way to Mukiri. It is submitted that considering the convenience of the wife, the matter may be the MC may be withdrawn from the family court at Hooghly and may be transferred to the which court? Senior Civil Judge. Senior Civil Judge Court at Hooghly. Expert. Learn counsel appearing for the husband has filed his objection, and learn counsel appearing for the husband submits that there is threat to the life of the husband if he has to appear before the court set of the read. It is stated that the father of the petitioner is a retired police officer, and he submits that it's not safe for the petitioner for the husband to appear before the court set of the read. He submits that if the matter may be transferred to Belgaum, which is about 45 kilometers for her, which is about 45 kilometers to the wife. It would be also convenient to her, and also from the husband's side also, it would be convenient. Having heard the counsels on either side, there is some decision on record. The reason that is stated by the husband that the wife, the father is a retired employee, as a police officer, and the fact that he is a paralytic patient. This court is not inclined to transfer the matter to any of the courts in between, as again the wife has to travel on each date of hearing to the court, and the husband also has to travel. When a transfer is made, if it is at the wife's place, it would be convenient to her. If at all there is any threat perception to the husband, he is always at liberty to move an appropriate application before the court, bringing it to the notice of the court about any of the attempts that are made. Or it is also that he can give a complaint to the police. Considering all this court is passing the following order. The MC number 344 of 2024, pending of the file of the principal family judge, Hooghly is withdrawn and transferred to the senior civil judge, Hooghly, accordingly allowed.
Number 65. Santosh Vinargu.
Transfer from Dharwad to Bangalore.
Belgaum to
Bangalore, which is about 5.
MC is official. MC is official.
154 of
Counsel for the present petition is filed seeking transfer of the MC pending on the file of the family court Bangalore to Belgaum or Belgaum to Bangalore. Pending on the file of the family court Belgaum to Bangalore. It is submitted that the wife is residing in Bangalore, and considering the distance of 500 kilometers, the MC may be transferred to Bangalore. Considering the submissions, there shall be stay of all further proceedings on the file of so and so. But till the next date of hearing, petition shall take out hand summons to the counsel appearing for the respondent before the trial court. In addition, the registry is also directed to issue notice to the respondents. Yes.
Number 66. No.
Wife's petition seeking transfer of MC case from Hungund to Babu.
Distance?
Around 60 kilometers.
When is the MC?
It is next is on 31st March.
When is the MC filed? Which year?
22 minutes.
Then file the.
She is also filed for conjugal rights.
File the court proceedings. Let it be, but will not transfer. For file the court proceedings. What is the stage of the land counsel for the petition shall place before this court the proceedings of the trial court to know what is the present stage of the proceedings before the family court. Yes, next. When can you?
Next week.
Unless this matter on 28th.
28.
Yes, next.
Number 67.
Respondent does not describe his certificate.
under section 13(1)(b)(1).
Where
One or
is-
two Hubli Melon.
Huh?
One or two Hubli Melon.
What's the distance?
84 kilometers Melon, more than
Which year is the MC?
2023, 24 Melon.
It is submitted, the present petition is filed, seeking transfer of,
One or two Gadag. MC number 24 of.
seeking transfer of MC number 24 of 2024. Pending on the file of senior civil judge and JMSA Ron to the family court at Hubli. And you submitted that, what is the distance?
84 kilometers.
The distance between both the places is 84 kilometers, and it's very difficult for the wife to travel. Considering the same, they shall be stay of all for the proceedings on the so and so. Same, the notice, and in addition, registry is directed to issue notice. Yes, next.
Seal number 68. Very good.
High Court ordered the interim maintenance of 10,000.
Wife, how much is what is your income?
Income is 45,000.
Then why can't-
After loan application, Finality is 35 lakh. The monthly installment is 21,000.
So remaining is how much?
Region the handicap Finality also. She also Finality working as a teacher.
20, so remaining amount is 24.
Well, she is also working as a teacher.
What is her income?
15,000 income is month.
Please come, let counsel the petitioner submits that. The court has failed to consider the loans and other deductions. And further, wife is working, and still the court had granted maintenance of an amount of rupees 10,000. The petitioner, considering the submission, there shall be stay of all further proceedings pursuant to the order dated so and so. On the conditions, the petitioner shall deposit an amount of rupees 6,000 for 5th of every succeeding month, and the arrears at 6,000 from the date of petition till now shall be paid within a period of 8 weeks from the date of receipt of the copy of the order, say default order, and the petition is permitted to take out handsome amounts on the counsel appearing before the trial court and shall file a memo to the defective and all that, no? Give a date for filing the memo. It's by 10th of December. And same, if even the memo is not filed in the earlier matters also, it stands dismissed. Yes.
And request is money of 5,000.
6,000 is fine. Yes. Next.
Number 69. Did you carry that?
Yes, madam.
Yes.
My lord, this is the husband's petition.
Hmm.
The respondent herein have approached the honorable tribunal by filing the petition criminal remissions 208/24 under section 125 of the share issue. Plus the interim application is also filed to grant it.
How much is granted?
4,000 is granted, my lord.
What is your income?
Income is 40. 46,000, madam.
Will issue notice.
46 my lords, then 4,000 each is my direct. Reduction is totally 12,000 is remain. Out of 12,000 I have to maintain my.
When you are having a salary of 46,000, how come your take home salary is 12,000?
Yes, madam. Reduction after reduction, my lords.
What deduction?
If the kindly told my lords, I have produced the salary certificate at page number 38, my lords. And at the E.
Then how will those people will live?
My lords, I am ready to take them. They are not ready to come and join with me. They want to.
But if they are with you, you don't have to spend any amount for them.
My lord, I have made almost all the facilities. Repeat our education is I am ready to share with them. But at the instigation of their mother and brother, they are not residing with me, sir. And the other trying to order.
What is this OT 21,030 to what is that? What is meant by OT? Page number 38.
Page number 38, my lord. Gross salary is 47,915.
No, 21030. What is that? 21030.
Overtime is, I think it's overtime.
What is that?
LIC.
LIC I can understand.
Yes, my lord.
What is that 21030?
I'm sorry, my lord.
Please ask your client what is that OT.
Okay.
Pass over. Yes, sir.
Seal number 70. A part.
Yes.
Five questions, similar questions.
Huh.
Excise Act.
Oh, Excise Act.
Yes. All these petitioners are of star hotel owners. Star hotel owners.
Star Hotel.
Star hotel owners. And the star category was granted, and thereafter excise license is granted to them. For in the
CL7 or
6A.
you have 6A license?
6A. And this has been going on since 8 to 10 years. They are renewing every year. And even the 24-25 also they are renewing. The license is valid till the June 2025. Last July 2024 they are renewing the license. And the condition, one of the conditions there that is, I have to get my star category renewed. After 5 years or 3 years, the star category.
No, your tourism department has given that that status till when?
5 years.
That completes by when?
Initially 5 years, and then it was renewed. I filed my applications for renewal also. That is under process. And it is going on in process. They have to visit and then instruct and then to grant. And under that condition.
So unless and until that is granted, you cannot have a 6A license renewal.
No, but they have given me the time, even the excise department also, under those conditions only they went on renewing it, with the condition that I have to get the renewal license. And this, even this 24-25 license was renewed with that condition only. Then suddenly in 2000.
No, I want the dates on that.
Yes, sir.
When is your, when you have been granted 5 years?
Yes.
When that 5 years period elapsed?
2018.
So from 2018, there is no renewal to you as a star hotel.
It is under consideration for pending.
No.
Renewal is not.
And then in that case, how come they are doing it every year?
They are taking undertakings because of after seeing that.
It is not about undertaking. When you don't have, you don't have. If you don't have, how can in the anticipation that you will be getting or it will be done, how can they give?
No, considering that, what happened is we filed application for renewal, and that is under process. Process also takes up to know, and process is only they have to come and visit, and then inspect and grant it. That is the tendency in the throughout the state and India is
so
down.
from 2018 till now it is pending.
Pending. Even the tendency, the application tendency also.
Then what did you do when it is pending for so many years?
We have pursued. We have
not pursued. You have a legal remedy also, is it not? When they are not doing something.
No, they Varshik may see page 23.
23. Yes. Yes.
Page 23 on my application, it shows all these things which we have pursued, and they say that they have to come and visit, they have to fix the date. That is the difference between difference of opinion between state government and central government. And under that, they have directed the state government to inspect and report. That is pending. In one of the cases, they have fixed the date of inspection also. That is also pending. And in the meantime, the 2025 license, they have renewed it. They have taken my license fees, etc. for 1 year also. And suddenly they issue a notice in September 2024 and say that within 30th September you have to bring the renewed license, otherwise you will cancel. And that also, if your lordship is pleased to see, under section 30 they have initiated that action. Section 30 says 30 days notice is required to be done. And that is also not there.
First of all, before all this, they are too liberal with you from 2018.
No,
and
we still
no. Condition precedent for a notice for a license under 6A is that you should have this category of a star hotel. When you don't have, when your some application is pending consideration, that is not a concern of the excise department. And that I can understand matter of one month, 2 months, 3 months, but not years. 2018, 2024, I think like something is wrong with the excise department for renewing your license from 18 to 24.
No, considering the fact that
How can they construct? It's not within their realm at all.
No, but initially star category was granted, and the renewal is there.
Because granting a star category is not within the powers
No,
of
that is
the.
granted by the.
So it is between tourism department and you.
Tourism department itself initially was granted, then it was to be renewed.
That's what I'm saying. That is between you and the tourism department. Excise has nothing to do. Excise will grant the permission provided you are a star hotel. If you are not a star hotel, then you will be in CL7 license. You will have like any other hotel. And not having the license, not having renewed your star status, you are enjoying it from 2018 to 2024.
Even we have notice also, what we are giving the reply is we are pursuing it, we will bring it and.
No, it's not that. It's something we are not.
Considering that till date they have accommodated us.
They cannot accommodate in the opinion of the court.
In the middle of this year, all of a sudden.
At least some wisdom prevailed on them at least now.
That also, the notice required to be issued is 30 days. That is also not done. Only 10 days notice is given.
First of all, there is no, it is like you have no, you're seeking a mandamus, seeking a direction to them.
Stay up there.
No. That order by way of
Yes, seeking mandamus to the tourism department and this tourism department to immediately process our order. They are keeping, because more state there are a lot of.
Where is that application? That where is that mandamus? That where is that relief you are seeking? Issue a writ in the nature of granting the impugned order. It is a show cause notice, or it is what is this order? What is this impugned order dated 3010?
Withdrawal.
Huh?
Withdrawal
of the license.
License was.
Written in the nature directly respondent to complete the inspection process of petitioner.
Since from long years, we are asking them to produce the star category license.
At least you
They
realize
have not at all produced.
No, you are realized. If they have not produced, what are you doing from the last 6 years? How can you do it?
They have to produce, madam. They have to produce. They are giving us.
If they are not producing it, you shouldn't renew it.
Every year license they are coming and saying we will produce. The liberally they are granted.
Why?
They are granted for them.
But liberally do this year also.
No. That's why from 2018 they are asking to give the star category license. They have not produced, and they have also made request this year also. Yes, sir. At the annexed scheme, kindly seen, annexed F. They have also stated we will produce it. From that date to till today, and seriously viewed this year and directed.
Why you are not? What the court is asking you is why you are not being serious from 18 to 24. Suddenly, why you realized it?
No, why?
That's what. Why are they doing it?
Yes, sir. That's why this year it was cancelled. From giving so many opportunities as given to the petitioners, they have not at all produced. Hence, this year they have taken steps to cancel and also withdraw.
You have kept quiet from 18 to 2024 without even filing a repetition before this court.
Petition is not right, but.
That means it shows that you are taking it light. Otherwise, you would have come before the court, or you should have availed the remedies available to you. And why should the court come to your rescue now?
No, that is not only my request is. It is in July 2024 they removed it, and with the condition that I have to get it, I have pursuing it, and even in the middle of the year suddenly it is.
The problem is to start with. There are no this thing on your part.
I believe with my
on something they're doing illegally without their authority, without a source of power. When they're doing something, and the court will not tell them that okay, you committed illegality, follow the procedure.
They say that I should have produced it before 30th September.
But you should have produced it from 2019, 2020, 21, 22, 23, 24. You are enjoying a facility which you are not entitled to.
But my request is.
I can at best an order that this court can grant you is this your prayer number 2.
No.
That only we will. Not the court cannot grant you the other relief. Who appears for this department? You only represent that also?
No.
Respondent number 5 and 6. The Karnataka State Tourism Development Corporation. Any counsel for this?
No, sir. Up to 5 I am appear, madam. Up to 5 I am appear. And for 6, somebody.
Who has to do it? 5 has to do or 6 has to do?
No, both of them together have, no. 6 has to give the category, stock category, not the Department of
So 6,
Karnataka.
central government will be appearing.
Yes.
5 you appear.
Yes.
Please get instructions will list this matter on Monday. Why this process, either you have to reject it or you have to grant it. Why this, eternally this process will be going on? So please get instructions from 5. 6 who will appear?
Central. 5 also somebody is appearing. Along this one is the Department
No,
of.
6 is the central government.
5.
Who is the counsel for the central government?
MD Kanini.
Print the name of so and so.
Independent.
For the respondent number 6. The government leader
Please.
shall get instructions from the 5th respondent why the application of the petitioner is kept pending from a long time. List this matter on 23rd Saturday.
The losses permission 4 and 6 MD Kanini.
4 and 6.
4 and
4 and
1,
6.
2, 3 and 5.
1, 2, 3
And 5.
and 5. Then High Court government leader takes notice. Next.
I will tell 28. 28.
No, why I said the 23rd is, by the time even if you don't get instruction, the central government council has to appear.
I am not available up to 25th. That's all.
No, it will not be, that central government council will come, so that day we'll ask him and then we'll adjourn it to 27th.
Please.
Yes. Next.
Posted and preliminary.
Where is it?
Preliminary.
It will come in the same, listed in the same caption. Yes.
Not same. 71 to
71 to
75.
same order in all the matters. Yes.
Department number 75. Rejection portal.
Statement of objections, copies of.
Yes. What is the matter about?
No, it is a 7 to 11 application.
Yes.
Citation also not done.
Yes. Let's see the order.
7 to 11 application is rejected.
What is the suit for?
Suit for declaration of title and amendment.
Oh, this is the case 1967.
Yes. It is the contention that my lord, they are in possession and there is a registered sale deed, therefore.
Is Mr. Counsel, you ready? Paso.
My lord, I have produced certain documents also.
Let's see, let me know.
Please.
Paso. Yes.
76. Salvation Group, no. Rajshekar Burji.
Why is it adjourned? At the request of counsel for the respondent, this is matter 2011.
My lord,
One for possession.
You are for the petitioner? Yes.
Suit for the respondent has filed the suit for possession and setting aside compromise which we earlier taken before the No.5. Meanwhile, we have the present petitioner has filed the application on the rejection of plaint. The said application was rejected only on the ground that we have secured the alternative prayer. But in this pleadings, both of the pleadings were at
And what about the separate suits for saying that to set aside the compromise decree?
his entire awareness of the
Up to that, on that side the suit is, please come to the page number. Decree of possession be passed awarding lands and so.
first prayer.
So the partition obtained in OS number were fraud on the plaintiffs dated, we opened. So this OS number 233 of 2005, it's a compromise decree.
Yes.
Compromise decree passed by the,
Lokata.
then what is the remedy?
The same court has to go to file the application of reopening.
But this prayer B was my alternative prayer. In the earlier suit, OS number 233.
Something which cannot be,
No.
however you frame it, without this you can't have that.
I'll just submit to that.
No,
The
your,
OS
no, your prayer B should be your first prayer. A is the consequential prayer.
In OS 233 by 2005, my lord, there was a partition between the plaintiff and the defendants. Certain shares were allotted to the family, Lord. And out of that partition, Lord, I am seeking for possession of my share in the estate. I'm not straight away. I'm not asking for reopening of the judgment and decree passed in 233 by 2005. They admit that, you know,
No, even for that also. Something is granted to you by virtue of a judgment and decree in OS number so and so. For that, if you want, if that decree is not executed, what you should seek for? You should seek for execution of the decree. If your argument, as you say, that my prayer A is this.
a fraud has been played without assigning any particular share to the
Even fraud also, a judgment and decree on the ground of fraud if you are alleging, if it is passed by the Lok Adalat, what is the remedy?
Now, my lord, the suit is not filed in the year 2017, my lord. And matter was adjourned for argument, defendant's argument. At that point of time, my lord, the supplication is filed. And in the evidence, my lord, in the cross-examination, he has admitted that, my lord, no share has been allotted to the plaintiffs. So, my lord, only to overcome the evidence, my lord, recorded against them, my lord,
First of all, no, we'll not go into all those issues.
No, I'm just bringing to my lord's notice the conduct of the party.
No, that might be, we cannot, already the manner in which the civil litigation is going on, it has no end at all. And if the court starts entertaining these kind of suits, then there is no end to the litigation. Now, the parties in this suit will go and file another suit seeking clarification in this suit, and they'll go somewhere else, then there is an end to that.
Since they admitted that do not have a share in the property.
Then let you execute it.
So, no, that was defeated by virtue of fraud played in the compromise.
Then you have to question that fraud that has taken place.
So,
But for the same court, filing a writ petition.
For that, the suit, separate suit is filed,
which is not maintainable.
for alternative prayer also.
It has to go.
Granting me liberty not to.
No, liberty cannot. That you have to work out.
To file necessary application in the earlier suit, not so that I can rectify the compromise.
That's for you. If it is legally purposable, you will do it. If it is legally purposable.
Seems to not the only remedy available to the plaintiff was to file a writ petition challenging the order of local.
Why did you not do it?
No. Yes. Now, the recent judgment of the Honorable Apex Court and this Honorable Court is that the writ petition is also not maintained.
You have to go before the very same court.
Same court seeking for a restoration of the writ.
Correct.
So that liberty.
What I am saying is, yes. Now you will go before the so-and-so court or whatever court. If it is within, now you have to explain to the court all this. Why should this court tell the court to entertain by giving a liberty to you? This court will be condoning everything.
No, that observation will be made, not the liberty.
I will say that not liberty. I will not say. I will say whatever are the remedies available to the plaintiff, if in accordance with law, he can avail.
Otherwise, my lord, my suit is also is dismissed, not by rejected, not the instruction for this application, and there will be no remedy.
No, when you are supposed to have, you have to the counsel. This plaintiff is not a party in person. You know the legal, what are the remedies available to you.
2017,
even in 2017 also a writ petition was maintainable. maybe in the later position, now it is the same, before going before the same court. When you had a remedy, then you kept quiet. You kept quiet and you filed a suit like
The
this.
reason, my lord, was the first prayer. Only the suit for decree of possession was the reason, my lord, sought
No,
by
that is precisely A is execution of OS. And you say some fraud, second, that is going before the very same court. Any of your A or B are not possible by way of a separate suit.
that.
That I'll record. If it is whatever is permissible, then you can avail.
So, my lord, may I observe that, my lord, remedy available in restoration of OS 233.
No, see, the remedy of the petition is not filing a separate suit.
Then what
There are one and two, and if he is entitled in accordance with law, he is at liberty to pursue.
No, my only request is, my lord, the observation of this honorable court, my lord, to make necessary the grievance, my lord, insofar as restoration of OS 233 or together. Otherwise, my lord, my all doors will be closed, my
What to
lord.
do? Your client was not doing what he's supposed to do. The present.
Admittedly, my lord, the compromise petition is also placed before my lord, last occasion, my lord. If the compromise petition is seen, my lord, that my lord, that the fraud has been played, my lord, without allotting any share to the parties, my lord. Admittedly, my lord, they have share in property. Just because, my lord, he happens to be a illiterate, my lord, instead of his name, my lord, the defendant's name has been mentioned in the compromise petition.
Agree with the orders passed in I number 6 and OS number 427 of 2017 dated 8 November 2022. The defendant is before this court. The respondent here and who is the plaintiff had filed the suit seeking the following prayers at page number 18. Page number 18, extract the prayer. In that, the defendant had filed an application at order 7 to 11, seeking rejection of the plaint.
When the matter was posted for argument, when this matter was posted for the defendant's argument,
When the matter was posted for defendant's argument, an application is filed under order 7 to 11, stating that, where is that application?
my lord will find it, my lord. In page,
Stating that the defendant in the present suit has filed OS number 233 of 2005 on 29/9/2005 before the court has filed so and so, and during the course of trial, the suit was entered in compromise with the intervention of the village elders, and accordingly, the plaintiff and defendants have filed the joint compromise petition dated 21/1/2006 before the court, along with the joint memo submitted by both the parties, praying the court to refer the matter to the Lok Adalat, and the matter was referred to the Lok Adalat. And as per the terms and conditions of the compromise petition, a final decree was drawn on 5/7/2006. And accordingly, the parties are put in possession of the respective allotted shares, and they have got entered their names in the ROR of their respective allotted lands by certifying the MR by the Revenue Authority. According to the defendant, as per the said compromise, he is having absolute right, title, and possession of the suit Schedule A properties. It is stated that after lapse of 12 years, the said compromise decree was challenged by filing the present suit by making false allegations. According to the defendant, the suit is barred under Order 23 to 3A of secrecy, and a separate suit is not maintainable. The trial court, by order impugned, dated 8th November 2022, had dismissed the said application filed by the defendant, observing that
page 12.
that the plaintiff, apart from seeking that the compromise is obtained by fraud and that it's not binding on him, is also seeking for possession of the suit scheduled property, wherein the plaintiff had given the possession to the defendant when he left to Maharashtra for avocation during the time of drought, in the year 2006. When such is the case, for the said relief, the suit cannot be nipped in the bud by invoking Order 7, Rule 11 CPC. The court will not lose sight of the fact that the plaintiffs are not only seeking the relief of reopening of the partition, but rather sought the relief as an alternative relief for the main relief of possession. Full stop. When such is the case, viewed from any angle, the court do not find any reason to reject the plaint. Furthermore, it is also settled from the catena of decisions that the question of res judicata is not a question of law, but which is a mixed question of law and fact, and accordingly dismissed and rejected the application filed under Order 7 to 11. Next paragraph. When counsel appearing for the petitioner, defendant submits that when a compromise decree is passed and after lapse of 12 years, when a separate suit is filed saying that the same is obtained by fraud and also seeking recovery of possession, the court ought not to have allowed ought to have rejected the plaint. He submits that when the petitioner is saying that a compromise decree is obtained by fraud, earlier a suit would lie, a petition would lie, and in the light of the latest position, he can maintain only a suit, maintain a petition before the very same court, but he cannot maintain a separate suit. He submits that he alleges fraud after 12 years, and by virtue of the decree that is passed, the parties are put in possession of their respective shares of the property. All these aspects were not considered by the court. The court, in a very mechanical manner, that the court can, on a mechanical manner, that the suit cannot be dismissed at the threshold, and a petition filed under Order 7 to 11 has dismissed the petition. Next paragraph. That counsel appearing for the respondent plaintiff submits that a fraud is made by the defendants, and he was, as per the compromise decree, he was not even allotted any share. The court had rightly observed that the main prayer that is sought by him is recovery of possession, and questioning the decree, compromise decree, is a consequential prayer. Accordingly, it is submitted that as the court has rightly observed that without even looking at the consequence, the second alternative prayer, the first prayer is maintainable, and a full-fledged trial has to be conducted. He submits that by playing fraud, no property is allotted to him, and all these things have to be adjudicated by the court by way of a full-fledged trial, and court had rightly dismissed the petition filed under Order 7, Rule 11. Anything else? Having heard the counsels on either side, produce the material on record. This court, in the preceding paragraphs, has extracted the relief that is sought in the suit. He states about a compromise that is entered between the parties, and according to him, no share is allotted to him, and he also seeks recovery of possession. However, cleverly the plaint of the prayer is drafted, and what remains is that it revolves around the fact of the compromise. Unless and until that said compromise, the decree is set aside, holding that a fraud is committed by the defendants, the petitioner cannot have the relief as he sought in the prayer number 8. And prayer number 8, full stop. If he wants to question that compromise decree, or he is dissatisfied, or he alleging fraud, for that he has to go before the very same court as per the law that is holding the field as on today, or at the time he filed the suit, he has to filed a writ petition questioning that, questioning the compromise decree, which is obtained by fraud. Very interestingly in this case is, when a compromise decree is passed in the year 2016, the suit came to be filed in the year 2017. And now, from 2017 to 2024, the case is pending. This court is not able to appreciate the submission on behalf of the plaintiff that, under the observation of the court, that the order 7 to 11 and a petition and an application under order 7 to 11, all these things cannot be decided. Looking at the plaint alone, and the facts that are stated, and the reliefs as sought, he cannot maintain a suit, and the court ought to have rejected the plaint. The plaintiff ought to have availed the remedy of questioning a compromise decree, which he has not chosen to. During the course of arguments, then counsel for the respondent plaintiff submits that a liberty may be granted to the plaintiff to avail the appropriate remedy. Considering the fact that the earlier suit, the compromise decree was of the year 2007. 2006. So 2006, final decree 2007. No, I think in your objections it is there.
Compromise decree number 21/2006.
Final decree 5/7/2006. A compromise final decree was drawn on 5/7/2006. 2006, and the suit is filed in the year 2017.
16/6/2007.
If the law permits, the petitioner is always the law. If it is in accordance with law, if the law permits, the petitioner can always avail the appropriate remedies available to him. Accordingly, this court is passed in the following order. The order dated so and so is set aside, and consequently, IN number so and so is allowed, and the plaintiff the application is allowed by rejecting the plaintiff. Number 2, the plaintiff, if in accordance with, if the plaintiff is at liberty to avail the appropriate remedy, if the law permits and in accordance with law. Yes, next.
Number 7.
Please. Petitioner.
Yes. It is clear. Your GO is not about prospective or retrospective. Even before that, there is a judgment of this court saying that an interpretation was made. Subsequently, the GO has come. So, the petition is entitled for that because he falls within that less than 50%. Pass on over.
As per my submission, the GO issued by the government, it is in prospect. It is not.
They have clarified the GO is clarified. They have clarified it. Now, when is the order passed with any rule that is for that there cannot be any argument on that.
This
order
will take effect from August 16th of 2024. August 24.
Let's see that. The senior counsel, where is the GO? You read yesterday.
Yesterday I read the rules. It is insertion, not prospective. Always insertion, substitution, and addition.
So let's see where is that.
Rule 17B.
No. Find it. Which page number?
Please, ma'am. Page number 3 of the amended rules. Gazette notification.
No, you have filed, I thought you have filed along with this compilation.
Separate. Yesterday I have made available to the Honorable Court. Along with the judgment I have submitted.
Title, from
Yes.
title.
The
Commencement of title and commencement.
proviso shall be inserted. Inserted means it should go to the original rule. Substitution and addition is subsequent.
Maybe called the Karnataka.
Inserted. Yes.
License amendment rules 2024. They shall come into force from the date of their final publication. It was published on 16th of August of 24. And it is
Please understand.
retrospectively it will not applicable for them.
Please understand.
Please.
In the rule book, there was no discussion or there was for example, if the rule says about any transfer or this judgment has clarified that even before you issued a GO, the judgment has clarified that they are not seeking something in the teeth of the this rules, amended rules. They are seeking something as per the order of the court.
Oh. Yes,
As on that day, you didn't have that amended rules.
Yes, that time that
You
was
didn't
not.
have.
That was not. in
No,
existence.
anybody prospectively, anybody will have. No, why?
Yes.
What about the judgment?
As per that order passed by the commissioner.
Not the commissioner,
No,
this
Excise
court.
commissioner, Excise commissioner.
Not
That is-
Excise
I
commissioner.
will take my lord to the impugn order at page 50.
You have the copy of this order?
No, I will not.
That you have
We
to
have
look at.
not.
Please look at this order, we will take it up in the afternoon. This order passed by Justice Vineet Kotari.
Yes.
Give a copy of this.
Yes. One submission is that the collector allows my representation, directs the refund. Deputy Commissioner of Excise, who is below him,
We will
files
pass
an
orders in the afternoon. We'll
Yes.
pass orders in the afternoon. We'll go through that, Mr. Ranjit. Yes, next matter.
around 3 o'clock, my lord, so if it can be.
2:30 I have another matter, so it will take some time. Yes. Yes, 79?
79?
Oh, yes. Oh. I think yesterday you were not there. That's why it's passed over. If yesterday passed over, again, for you to come to the court again, it
My
is.
friend is authorized inconveniently actually.
Yes.
Yes, allows the wife and two children. I'm not residing at Dharwad. I'm not, she has initiated also criminal miscellaneous civil maintenance. It's listed for tomorrow for final judgment. Also, the husband is working. He's residing at Rome. It's near about 95 kilometers from the Dharwad. Now, there's no difficulty for the wife not to attend at Rome also. Since
Why?
he's getting interim maintenance also and also and first thing also, the husband has filed such a nice petition. Now, till today, Malords is ready to take the child and Malords wife.
Here we are not on the merits of the matter. We are on the point of convenience. Yes. The present petition is filed, seeking transfer of MC number 69 of 2024, pending on the file of the senior civil judge and JMSC at Ron to the principal judge family court at Dharwad. The facts of the case are: the marriage was solemnized on 14/5/2015, and in the wedlock they gave birth to a son and a daughter. In view of the disputes between the parties, the wife had filed criminal miscellaneous number 149 of 2022 on 17/2023, seeking maintenance at Dharwad, at the principal judge family court at Dharwad, that came to be allowed, and the children were awarded rupees 3,000 each as maintenance. And the husband had preferred an application under 125(3) of CRPC before the principal judge family court at Dharwad. It is a case of the wife that as a counterblast, the husband has filed a petition, that is MC number 69 of 2024, under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. In that, on 25/9/2024, the wife had received the notice. Next para. Then counsel appearing for the petitioner wife submits that the distance between both the courts. How much is the distance?
123 kilometers.
120? 123 kilometers, and it's very difficult for the wife to travel, and she has to take care of the children also. He submits that considering the inconvenience caused to the wife, the case may be transferred from non-Braun to Dharwad. Dharwad. Next paragraph. When counsel appearing for the respondent, husband submits that the wife is already getting the maintenance. The husband is working at Braun. It's very difficult for him to travel to Dharwad, and he has to take care of his old age parents. I submits that no grounds are made out for transfer of the petition from Braun to Dharwad. Next paragraph. Having heard the counsels on either side produce a material on record, the wife had already filed a criminal misdemeanor seeking maintenance, and the same came to be allowed. And husband has preferred a petition under 125 of the CIMC before the family court at Dharwad, which is pending consideration. And thereafter, husband has filed the MC before the courts at Braun, that is MC number 69 of 2024, considering the distance of 123 kilometers, and the fact that she has to take care of the children. This court deems it appropriate to allow this petition. Accordingly, so and so is withdrawn and transferred to so and so. Accordingly allowed. Yes. About this
DNA testing.
summary.
And they have already appeared. And on the last occasion, I referred to the judgment rendered by the Honorable Apex Court in the case of the
No, in the other case, why are you not, because in the MC case, he has filed an application for that DNA test. Why you are not cooperating with that?
No instruction regarding that material. Yesterday we are filing Vakala. We have only instruction with respect to this petition.
Get instructions tomorrow. What is happening in MC? This is not tomorrow.
May I request on Monday?
Monday. Because you are only insisting for
No, since
Monday. This is matter on Monday. At the request of the counsel petitioner, the counsel respondent shall get necessary instructions in this regard. And the instructions with regard to the application filed by him for the family court. Yes, next.
Number 8. Karnataka Commission Salem.
The order passed for the tribunal is 40%.
There are 81 to, only 81 and 81.1.
Yes.
What is the CRP? Wow, first CRP.
Lord, this is the latest revision petition.
Against which order?
Lord, the order passed by the tribunal, dismissing the suit filed by the plaintiff, seeking for declaration of title in respect of property. Dismissal.
The next one is?
Lord, insofar as the observations which are made before the order, Lord, are not in question with sufficient revision petition.
It's by the defendant.
It's by the second defendant.
You appear for the plaintiff.
I appear for it.
Who appears for the respondent? Where are they? Passover?
I have one partner matter.
List is marked on 23rd.
23rd, yesterday I requested for
This
Monday.
is matter on
Monday or Tuesday.
25th.
Wait,
Name of the
Which name? Delete the name of Mr. R.M. Kulkarni for R3. Your name is there.
No, Mr.
Vakal, yes. Delete the name of Mr. R.M. Kulkarni. Yes, next.
Wait.
Karnataka State Work Board against the judgment passed by the Karnataka Work Tribunal allowing the suit of the plaintiff, declaring that the suit properties are not gazetted property. In fact, gazette notification was.
I heard this matter.
No. Two cases are.
What is the other petition?
It has been filed by one of the interested person who had also arranged himself as a dependent before the work tribunal. As they claim that the property is a work property,
wherein they have got an interest to protect the work process.
So now the petitioner before this court is
The
Karnataka
work board, madam.
Work Board. Who has filed the suit?
Suit has been filed by respondent number 1 to
Tanjim Education Society.
Tanjim Education Society 1 to 6, my lord. They are all claiming themselves to be the officers of the said society.
And 7 is the Work Advisory Board.
That is the government party.
8 is?
8 is the person who has filed the other petition.
Oh, this is the next petition, yes.
8 and 9.
Let's just look at the impugned order.
May I request the Lordship to turn to page number 52, the operative portion of the order. Suit of the plaintiff is hereby declared. It is hereby declared that suit property wherein MAA Maulana Abdul Kalam Azad, that is MAA stands for Maulana Abdul Kalam Azad, High School is run and managed. Page 52, madam.
Is not work, they are declared as not work
property. And the notification 18/5/79 dated 7/11/2012 and 19/6/2013 are wide ab initio not.
Yes, I've seen that, yes.
That cannot be because the gazette notification was the.
What is the procedure to be followed before issuing a gazette notification?
Admittedly, in this case,
Use it work fact. Work fact. Let's see. How you issue a notification?
I'll come to that faster. How the gazette has to be notified.
So that's the only crux of the issue.
No, it's not that way. The subject matter involved is a registered sale deed purchasing the property involved in the case by the local public. The issue involved is not something different. What they have done in this case.
No, this is a suit filed in the year 2013. 2000. When did you issue the notification?
Notification is of the year 1979, my lord.
No, it appears to be of 2012.
No, they say that there is some other letter that has been written by the District Work Advisory Committee. That prompted them to go to the.
We will read the entire order.
No, I'll assist the court with respect to the entire order.
We'll read.
I start from the very page number 16 itself.
Yes.
This is a suit filed by the plaintiff against the defendant for the declaration declaring the suit property wherein MAA High School is run and managed as not work property, and the notification dated 18/5/1979. That is the first that they say challenges with respect to 18/5/1979, and thereafter this is not the notification. 17/11/2012 and 19/6/2013 are the order passed by the work board in pursuance of the order that to manage the issue.
We'll complete it.
Are wide as it is not binding on the trust society as registered under the Bombay Public Trust Act 1950, situated at Bailongal as well as for consequential relief of injunction restraining the defendant permanently not to interfere with the peaceful possession and enjoyment of the high school which are existing on the suit lands. This may make one request at this juncture, my lord. Two things are involved. One, the property.
No, we will just read, the court will understand.
The brief of the case of the plaintiff as traversed in the plaint are that suit properties were being taken by the Muslim Jamaat for the purpose of running the education institution, that in the year 1967, a society was formed by the bylaws and was registered under the Bombay Public Trust Act 1950, that is the Tanjim Education Society Bailongal, that the properties are registered in the public trust by virtue of a registration certificate issued by the Assistant Charity Commissioner. That in the year 1967, an Urdu medium high school by name Maulana Abdul Kalam Azad, that is MAA, was founded by the then Tanjim Education Society. That the said high school was inaugurated by the then Member of Parliament, F.A. Mohsin, in the
presidency of His Holiness Sri Mahanta Shiva Yogigalu of Duradundeshwara Mata Muruguru. It is awarded that the said trust committee under the Bombay Public Trust Act built additional school building which contributed funds of the MP and MLA, that the suit property, that is the society manage and supervise the high school and the marriage hall uninterruptedly from the year to year till this day with the changing committee. It is awarded that since the Bombay Public Trust Act is now abolished, as per the direction of the Honorable Supreme Court, and thereby the direction was given to all the district commissioners and the district registrars to register and renew the trust societies. Such societies were allowed to be registered and renewed by the district registrar under Section 25 of the Karnataka Registration of Societies Act. Therefore, the plaintiff got the suit trust society registered under the Societies Registration Act. That therefore the same has been duly reviewed and legally and the authorities after complete satisfaction issued a registration certificate dated 30th/12/2009 and the tenure of the plaintiff's committee is still subsisting till 2014. It is awarded that the defendant number 3 and 4 tried to enter into a management of the two trust society but did not succeed in their venture. Therefore, there is a cold rivalry and jealousy of the defendant number 3 and 4 and their group, who are the close relative by blood and affinity. That the said group adopts harassing tactics and try to threaten the peaceful working institution at 500 towns. The award that about 1 to 2 years back, the then headmaster Sri L. Dorgal, who has appointed by the said trust society and was provided all the protection by the plaintiff society committed a grave financial offence in the MKA High School. Therefore, plaintiff had taken legal action as per the law and to the knowledge of DEO and DDPI Belagavi. Thereafter, it became inevitable to suspend him under the information of the Commissioner of Education that the said delinquent headmaster malafidely, as a matter of revenge, collected the defendant number 3 and 4 and their group, tried to interrupt in the administration of the plaintiff trust society, putting them in a group with the similar name of a suit trust society as Consumer Education Society by Longa. That such of the dispute between the said trust society and so-called another parallel society were inquired into by the education department and the police department. That the plaintiff suit trust society was genuine and legal, and therefore defendant number 3 and 4 as well as their group were kept in abeyance and distance. That the said headmaster inspired and created false and hollow documents and made defendant number 3 and 4 to form an illegal committee under the Work Act. That in this regard, the work and decisions of the defendant number 1 and 2 is tolerable, and defendant number 3 and 4 took the chairman of the said committee in their hands by illegal way, and therefore the defendant number 1 and 2 for the first time issued illegal order dated 7/11/2012 against to the establishment rules of the business of the state of Dharwad. That the said decision was taken unilaterally as no notices were given to the plaintiff suit trust society. That the said documents were concocted forged document as the plaintiff suit trust society was never and is never a work property. That the administration over the suit property right from 1967 till today is only under the Trust Act, and the bylaws approved by it under the Bombay Public Trust Act. Therefore, the defendant number 1 got notification as narrated in the awareness of the claim for the first time, and it issued order on 7/11/2012. That the plaintiff society came to know that the alleged notification 18/5/1979 was kept secretly by the said board when no such notification was ordered or published in the time between 1978 to this day. It is awarded that the alleged notification dated 7/11/2012 is so wide and hollow, sham and never acted upon by any authority. The defendant number 1 and 2, their staff members are responsible to keep under the darkness of the plaintiff society. that there was no any constructive until today. Till today, there is no any respect to knowledge and information to the present plaintiff society. It is our that after the order dated 7/11/2012, on the defendant number 1, the present plaintiff, by the defendant number 1, the present plaintiff came to know that the said notification was kept secretly with them. Therefore, from the month of November 2012, till filing of the suit, plaintiffs have approached the defendant number 1 to supply the certified copy of the alleged notification under which the defendant number 1 and 2 claim falsely the suit properties as the work property. That the defendant number 1 and 2 are keeping plaintiffs and persons interested in the suit trust society and its properties under complete darkness. That therefore, the right to sue has approved to the plaintiff in the month of July and August 2013. It is our that the plaintiff made a representation to the in person to the chairman of the board and also to the CEO of the board as well as the chairman of the district committee. That the said authority became adamant with mala fide intention to grab the trust society, suit society and suit property in the work board have taken care and control over the suit property till today. Therefore, defendant number 1 and 2 feel that the group of defendant number 3 and 4 will sign even illegally to reckon the plaintiff society and properties in the ambit of board, and just as a price to the defendant number 3 and 4, board has issued illegal and unconstitutional order in favor of defendant number 3 and 4. Therefore, the plaintiff, in order to remove the cloud over the title and ownership of the suit trust society, and it is necessary to file the present suit. It is our view that the plaintiffs have also brought to the notice of defendant number 1 board by requisition soon after the first information of the alleged work claim of the defendant by sending a regular petition under section 40 of the 1995 Act to correct the mistake of the board in holding that the suit properties and its societies to be the work. It has been also made clear that suit properties and suit trust society along with the institution have not been dedicated in the name of Allah to cover the suit property under the umbrella of the work act. The suit properties are made for secular purpose. That the activities of the plaintiff have not been based under the work act in the year 1967, 68, 78, 79, 85 and 2012. The government of Karnataka has never approved the subject matter of the suit as the work property under as per section 5 of the Work Act. It is our that there was no any resolution or there was no any person owning the suit property as owner to dedicate the suit property as work property. It is learned by gossip created with the defendant of 3 and 4 that one M.S. has made the suit property as a work property. That the said gentleman was not the exclusive owner to dedicate it to the works committee. Moreover, there was no any resolution in the general body and there was no any approval of the assistant charity commissioner to treat and include in the alleged work register. It is our that the order dated 7/11/2012 has created quite a condition and question of law and order in the plaintiff society in particular and in general in the public of the town. That the alleged notification are all not binding on the plaintiff, which are quite contrary to the circular dated 23/2012. That by the issuance of the illegal order, defendant number 2 and 3, with the help of others, filed a suit for injunction at OS 10 of 2012. That further, as the said suit was not tenable, hurriedly defendant number 3 and 4 and other persons withdrawn their case. Therefore, the plaintiffs are constrained to file this suit for proper redress. It is our that the order dated 7/11/2012 was obtained behind the back of the plaintiff without hearing the management members of the society suit trust.
We'll continue after passwords.
number 24.
What has happened to that?
It died, I have to take steps.
No, it is already over. What has happened in the morning?
This is tomorrow for dismissal.
20?
24.
24. Like council submits that. They take steps within 2 weeks. Default order. Yes. 24, that's in dismissal. This number?
2.
Why you are making mention now? What will happen is now everybody will start. Then it's difficult for the court. Anyhow, you are here, we will see in the afternoon. Yes. Huh? Your brother inconvenience also you can tell that time. No. This again, if I sign this, if the 24 matter is in this sense a problem, just check it out. Then you'll sign that. Huh? Which is the one? Serial number? What is that?
Matter for consideration.
At the request of the counsel respondent, this is matter on Saturday.
May request Monday. Small Monday.
Tuesday.
Yes.
ತಗೊಂಡೋಗಪ್ಪ ಅಲ್ಲೇ ನೋಡ್ ಮಾಡ್ತಾರೆ ತಗೊಂಡೋಗ್ಬಿಡು ಸಪ್ರೇಟ್ ಆಗಿ ಮೇಡಮ್ ಮಾಡಿಸ್ಬಿಡಪ್ಪ ಹೇಳ್ರಿ ಕನೆಕ್ಟೆಡ್ ಇಷ್ಟನ್ನು Western. Passport Kalpuri will Dharwad branch passport seal number 33. Here part.
Where is the other side? Oh, it is served. But yes, Mr. Ganapida. 33. You have papers?
One of the office submission raised by the registry is to serve the copy in the government. Serve the copy.
You served the copy. His office people have not given him the file. Huh? Let counsel for the petitioner give him another copy.
Please, madam, I'll give you.
Let counsel for the petitioner shall serve a copy on the government period.
The requirement has been taken from
Government period. IA number, but because IA number 2 of 24 is filed. When is that order passed? This court on 21/10/2024 has directed has granted a week's time to comply with the office objections, pending which the petition shall stand dismissed without further reference to the court. Thereafter, the petitioner has come up with I number 2 of 2024 to recall the order dated 21/10/2024, stating that. What is the reason?
They have complied certain
Submitted that they have complied certain objections, and as other objections could not be complied within the time in view of the order, the petition is dismissed. On 13/11/2024, when this matter came up, this court had directed the petitioner to comply with the office objections pending consideration of the IE. It is submitted that he has complied with the office objections. Considering the reasons stated in support of I number 2 and 2024, and as he has already complied with the office objections, the petition is the order is recalled and the writ petition is restored to fight the petitioner. That is not in the order. Next order, the petitioner shall serve the copy of the writ petition on the government advocate. This is matter of 27. Dismissed.
Number 50. Yes, sir.
Phone number 124 have filed a suit of partition, claiming under their mother, wherein the suit properties were granted by the occupancy rights of the suit properties were granted to their grandfather, one Act, wherein they sought for partition, their half share, which is supposed to allotted to her mother. Wherein the present petitioners have contested the suit by filing a written statement and filed an application on 7 July.
Who are you?
I am the defendant.
What is your relation with the plaintiff?
They are the
Family members?
family members, sons of my aunt.
So you are the sons of that person who has granted occupancy rights, and they are the children of the daughter.
I am also the children of one of the
Daughter.
sons.
One of the sons. That's what I'm
There are that is the genealogy.
come to the plaint that
Plaint members that right to perfect page number 30.
yes.
The genealogy at page number 34.
Page number?
34. Emu Peto 9, who granted with the occupancy rights. Shantabai is the daughter, who is the mother of the present plaintiff.
Mother of the plaintiff. That's what I said. You are the son's
Son for
son.
this person.
You are the son's son.
Son.
And the plaintiffs of the daughter's sons.
Daughter. The property was granted to the Emu 9 by the landowner. wherein we have taken up the condition that since the daughter has no right to seek for partition in the granted land.
That will be decided in a petition order 7 to 11.
7 to 11, that application came to the final. That application rejected by the
Basing on what the court should say that the daughter is not entitled for any.
because of the change in all these things. Change of law in this now.
Please come. Read with the order passed in. I number 3. Is number 141 of 2015 dated 24th November 2022. The defendant is before this court. The respondent therein, who is the plaintiff in the suit, had filed a suit seeking the relief of partition. The suit is filed seeking a declaration that the will dated 23/1/2002 executed by the plaintiff's grandmother in favor of defendant number 2 and 3 is null and void and not binding on the plaintiff's share in the suit scheduled property, and to declare that the plaintiff has got one half share in the suit scheduled properties and partition of half share of the plaintiff by putting them in actual possession of the property by means and bounds. It is a specific case of the plaintiff that their grandfather, Kemu Naik, was granted occupancy rights. Kemu Naik has a daughter and a son. The petitioners are the children of the daughter, and the plaintiffs are the children of the daughter, and the defendants are the children of the son. According to them, they have a right in the property in the property where the occupancy rights are granted in favor of Kemu Naik. In that, the present petition is filed. In that, the defendants have come up with an application and order 7 to 11 stating that the suit is not maintainable as the mother of the plaintiffs, being the daughter of Kemu Naik, she has no right in the properties of Kemu Naik. That application came to be dismissed by the court. Page number?
Page number, orders are from 13, operative question at 16. Thank you.
The court had considered the respective contentions of both the parties and held that when once the occupancy rights are granted in favor of the proposers, he becomes the owner of the property, and if he dies subsequent to grant of occupancy rights, the legal heirs are entitled for inheritance in accordance with the law of inheritance. And in view of the same, the application of the petitioner defendant was rejected. Next para, when counsel for the petitioner, defendant submits that the court had failed to consider the contentions that are raised by the defendant with regard to the maintainability of the suit, and the application is dismissed. Though no notice is served on the who is coming in. Having heard the counsel for the petitioner, present and written on the court. The suit is filed for a declaration and for partition. The plaintiffs are claiming claiming their right to the property, as they being the grandchildren of the grantee of the occupancy rights. That is the occupancy rights. Now it is a case of the defendants that the mother, that is the daughter, that is the mother of the plaintiff, is not having any right in the property. As such, the plaint has to be rejected. The trial court had rightly dealt with the issue and and the said ground taken by the defendants is no more available to them, and the court had rightly dismissed the petition. This court finds no reason to interfere. Accordingly dismissed. Next.
Number 15.
Morning, I was held at an unconfirmed.
Yes, what is this?
No, this is a petition filed for seeking an enhancement of maintenance amount,
How much was granted originally?
2,500.
2,500. What is the enhancement sought?
15,000.
What is the occupation of the respondent?
He's running hotel business.
As per the evidence on record, how much is their income?
Income.
He says that it is 1 lakh rupees.
Not they say, as per the order of the court.
There is not, nowhere it is stated. Even it is denied to that he is running hotel, and they also fail to prove that he is running hotel.
That order was challenged before this honorable court. That was confirmed.
Which order?
The 2,500 earlier was granted.
Was confirmed.
Confirmed. Subsequently, my lord, this petition was filed for seeking enhancement of.
127 they have filed application.
127 we have filed.
Now there is no change of circumstances, and they have dismissed.
When was the confirmation order?
Confirmation order is also given. 29/4/2014. 29/4/2014.
And now the
19/8/2014. 19/8/2014.
no, why there are no change circumstances 2021 after a long time?
Please.
She has to prove that whether my income is also reasonable or not. That is not made.
No, you're saying that change in circumstances, her requirements might have increased from that
That
day
is
to
properly
day.
not related before trial court. Your Lordship. Even trial court has not properly observed that.
Rise in the prices of essential commodities law.
As in particularly, they have not sought in the application.
Please read para number 7 from para number 7.
Point number 1. As mentioned herein above, the parties are not in dispute in respect of orders dated 29/4/2014, passed in the proceedings of criminal case number 240 of 2013, which was pending for disposal between the parties hereto. Therefore, this court does not have any discussions in respect of the said earlier order. The petitioner repeats her pleading even in her affidavit filed in lieu of her chief examination. In the cross-examination, she mentions that she has studied up to 7th standard. That since the year 2010, the parties hereto have been living separately. That she has been living so at her mother's house in Emilinodu village. She further mentions that very recently she has performed the marriage of her son too. She further says that she has not discussed with the respondent with regard to.
We'll satisfy this order. We'll satisfy and remand.
Please.
Agreed by the orders. Passed with criminal miscellaneous number 265 of 2021 dated 17th July 2023. The wife is before this court. Earlier she has filed criminal miscellaneous number 240 of 2023 seeking maintenance, and the court had granted a maintenance of 2,500. Dissatisfied with the same, she has preferred an RPFC before this court, and this court has confirmed the said order passed by the family court. Thereafter, she has filed this petition seeking enhancement of the maintenance to an amount of rupees 15,000 per month, and for the litigation expenses of rupees 10,000. The same came to be dismissed by the court. While dismissing the petition, the court observes that the wife had not adduced any evidence to show that the husband is having in the hotel business, earns rupees 1 lakh per month. No item of evidence is also adduced by the wife to prove that the husband has movable and immovable asset properties which also fetches him rupees 10,000 per month as additional income. The court observes that in the absence of any material evidence in this behalf, it is no good for the court to arrive at a conclusion that the husband has sufficient money to enhance the maintenance amount as ordered by the court on earlier occasion. And on this, the court had that as the wife had failed to prove that his income is 1,10,000, had dismissed the petition. Agreed thereby, the wife is before this court, and counsel appearing for the wife submits that the court had failed to consider that the amount of 2,500 that is granted in the year 2014, when an application is filed in 2021, the court, without considering the certain legal question and the law laid down by the Honorable Apex Court in Rashish versus Neha, and without even insisting for the husband and the wife, husband to file the statement of assets and liabilities, without any discussion, simply placing the entire burden on the wife, concludes that there is no material on the court. He submits that the court erred in coming to such a conclusion. Next paragraph. Then counsel appearing for the respondent husband submits that it is a case of the wife that the husband is having a monthly income of rupees 1,10,000 and she claimed 50,000. In that case, the burden lies on her to prove that what is the income of the husband, which she has miserably failed to do so. As such, the trial court had rightly dismissed the application filed by her, seeking enhancement of the maintenance. Next paragraph. Having got the counsel's one in this time, there is a material of record. The wife had filed this petition seeking enhancement of the maintenance. As per the law laid down by the Apex Court in Rashish versus Neha, both the parties are supposed to file their respective statement of assets and liabilities for determining the said dispute between the parties. In the entire order, there is no whisper about the statement of assets and liabilities, whether they filed or not. There is no discussion. Without there being the material on record, court ought not to have, without insisting for that, court ought not to have come to such conclusion that the husband's income is not 1,10,000. In the considered opinion of the court, the trial court had failed to consider, has failed to consider the case of the wife in the light of the settled law. In that view of the matter, the court is passing the following order. The order dated 17 July 2023, passed in Tribunal Miscellaneous number 265 of 2021, is set aside and the matter is remanded back to the trial court. Number 2, both the parties without further notice shall appear before the court by 16th of December, and thereafter within 15 days from 16th of December they shall file their respective statement of assets and liabilities. The court within 3 months from thereon shall consider the application and pass orders. Just next. Accordingly disposed of. Just next.
Number 69, also for
Maximum. In the salary certificate, it is shown as OT. OT. OT means others, my lord.
What is others?
Others. The petitioner has taken a loan of 1 lakh from the SBI that has been utilized for the benefit of the whole family, which includes the respondents also, to meet the medical expenses, education expenses, and day-to-day expenses. Apart from that, my lords, he
so
has.
you are having 21,000.
One minute. He has also opened the RD account in the name of all the respondents. Towards that, 15,000 will be deducted every month.
What is a RD account?
Recurring deposits. Recurring deposits in the name of the respondents only,
No,
madam.
it is like this. First of all, they have to live.
Madam, the petitioner is ready to reside with them. He has made several attempts to call.
Please understand, it's not about ready to reside with them. Instead of putting all the money in deposits, you should give them to, they have to live, they have to spend something to eat.
My lord, every month he has paid, order sheet may be received.
How much you are paying?
5,000, as per the order sheet, he has paid, the order is passed on 1/6/24. So he has paid the amount, my lord, sir.
Order is paid 1/6/24, but when is the petition filed?
Petition is filed on 30th of May 2024. Order is passed on 1/6/24. And as per the order, the petitioner has paid the amount. The order sheet may kindly be produced, my lords. The order sheet may kindly be produced. Page number 27, 26. 5,000 rupees paid, 5,000 rupees motive today, then 4,000 is paid. In this way, he has paid. And 4,000 will be the EMI, repayment of the loan.
Now, how many are there? Two, wife and
Wife for 2 children, my lords.
court has
Mother is
granted-
there, aged mother is there.
No. Court has granted how much?
The 4,000 each,
That's it is 4 into 3.
12,000, my lords. Out of 25 or 24,000, if 12,000 is deducted, the remaining will be 12,000. Out of the 12,000, it is not possible on his part to maintain himself and his aged mother, he is
No,
not.
but how will they maintain themselves?
Pardon me?
How will they maintain themselves? 3 people in 12,000.
My lord, let them come decide with me. I am ready to take
Notice.
and investigation of others they have filed.
Notice the respondents.
My lord, stay me kindly. Stay, my lord, please. It is posted for evidence, my lords. Otherwise, the very purpose for which the petition is filed will be frustrated, my lord. Please.
You're capable of paying, you have to pay.
Till they appear, my lord. Till the next date of hearing, my lord. Please, my lord.
No stay. 70?
Pastor Button, number 75?
Yes.
Oblige, my lord.
To respond.
What is this R1 deceased
Lords have already come.
or already come?
Lordship has times.
What to do? How many times the court? How many matters the court can remember?
My apologies.
Again, everything has to start afresh. This matter is heard how many times now, till now?
My sincere apologies for last occasion, since I had no instructions for the produced.
Yes, please argue.
My apologies.
What is it? No.
The recollector was. SEDD is of the year 1967. Suit is filed.
Suit is for?
Suit is for declaration and possession.
Declaration and possession.
Suit is instituted on 14/8/2015.
14/8.
2015. And they have admitted the SEDD in my favor, my lord, in the year 1967 itself. And they have also admitted pursuant to the registered SEDD, my name has been entered in the record of rights. They now say that SEDD is null and void.
Who are these plaintiffs?
Plaintiffs are the lord, they are the legal heirs of my vendor.
1967 vendor.
Yes. Your Lordship may kindly see my application once again. I will read or
Yes. Page number?
Page 50, my lord, paragraph 3.
Yes.
I state and submit that initially the plaintiffs instituted the suit on 14/8/2015, seeking a declaration that they are the absolute owners of the suit property and consequently relief of injunction. On perusal of the entire claim, it is the case of the plaintiff that the defendants have illegally entered their name in the record of rights by virtue of registered SEDD dated 3/6/1967. And in para 2C of the plaint, it is contention of the plaintiff that the said SEDD is illegal and void and also sought for prayer of possession. At the first instance, the plaintiffs are assailing the SEDD of the year 1967 in the year 2015, and possession is sought by virtue of amendment dated 1/2/2020. The Honorable High Court in W. So has passed a specific order in terms of Section 21 of the Limitation Act that the amendment incorporating the relief of possession and assailing the SEDD shall not relate back to the date of filing of suit, but the same shall be recorded from the date of filing of application in I number 11.
What does it mean?
Please.
What does it mean? I'm not able to understand.
Lord, it means, my lord, as per the Section 21 of the Limitation Act, if the court passes a specific order saying that
the limitation shall run from the date of institution of the suit, then, my lord, the limitation has to be reckoned from the date of institution of the suit, or otherwise it has to be reckoned from the date of application itself.
No, it's not about it.
Yes.
When they are seeking recovery of possession.
Yes.
Recovery of possession. From what date the date of limitation starts?
No, last time I submitted 2 decisions regarding constructive notice of lawsuit.
No, that is that transfer of property
Yes,
and section.
yes.
No, it's not about that.
Yes.
No, this order, when they are seeking possession, when they are seeking recovery of possession by way of an amendment, court says that it should be from the date of from 1/2/2020.
Yes.
Whether at that point of time, whether it is within the limitation or not, should also be was looked into.
No, no.
Where is that order? That order you have filed.
That is not. No, it's page 47.
40?
47. Operative code.
Oh, limitation of maintainability of the suit are all left open.
Yes. Lord, further I may, Lord, insofar as the relief of declaration assailing the SEBI of the year
Page number?
Page 51, Lord. Just now I. As insofar as the relief of declaration assailing the SEBI of the year 1967, the suit is on bail is hopelessly barred by law limitation. Insofar as the relief of possession is concerned, even assuming but not admitting the cause of action shown in the original case, since the amendment seeking possession is sought in the year 2020, the same is also written by Article 68 of the Limitation Act. Order 7-11D provides that the plaint can be rejected if the same is barred by any law. Honorable Appellate Court in the case of Marital construction reported in also held that the word law contained under Order 7-11D it not only include an act made by the legislature but also include a decision of the Supreme Court. Hence, in view of the judgment of Appellate Court in the Raghavendra Sharma C. versus Sriram reported in 2019, it says the suit of the plaintiff is liable to be rejected.
Please come to the plaint. I've seen this. Come to the plaint.
Your Worship may kindly see page 28.
Plaintiffs are the absolute owners of the suit property. The defendants are directed to hand over action and they don't even seek for cancellation or not binding.
Yes, your last occasion.
Either they say that it is not binding or
it is illegal by the.
Nothing has been sought.
Yes, and they have specifically contained, your Worship may kindly come to page 29. There are 2 C.
Let's read this.
Thus, it is submitted that on the basis of released and illegal document, the name of father of defendant number 1 and grandfather of defendant number 2 to 4, Nilappa Nivasa Sanaki, was illegally entered, and after his death, names of defendants have also illegally entered. Even though any entry made on the basis of a least stated vide, there was no presumptive value in the eye of law. So they were aware of this fact of registered SEBI in the year 1967 because that SEBI has been acted upon.
Where do they say that when they came to know? When they came to know, according to them?
That's reason not I relied upon the decision.
No, that I cannot. I'm asking from the
plaint is rejected on the ground.
pleadings. In the pleadings, where did they say?
Para 2B 28. Further, it may
The defendants were not at all in actual possession, cultivation, enjoyment of the suit property.
then there was no necessity to seek for possession.
But why was it ordered and why did you keep quiet?
Please,
When the repetition and order is passed.
they say that all the contexts kept open, then
So, first of all, your pleadings, your amendment cannot be contrary to your pleadings.
yes.
When you say that the defendant is never in possession of the property and you are in possession of the property, where is the question of seeking recovery of possession? That too, when there are no, so they don't plead anything subsequent cause of action.
The learned single judge observes that all the contexts kept open in the final disposal.
Sure, there need not be a final. First of all, that it cannot be ordered.
Yes, not one submission law. They say that all the contentions kept open in the final disposal. Rejection of plaint adjudication is also a decree under order 2 rule 2. So it is also adjudication on the final disposal of the suit also. And the judgment of 2000.
1 minute.
And your lordship may kindly see their prayer. At least they say they even does not mention the date of sale deed. By virtue of the sale deed is null and void of there is no prayer at all.
So this is one.
Yes.
Then where are the judgments?
I relied upon first judgment CRP 307 of 2020. Lord, para 15 my lord.
In a compilation or independent?
Separate CRP 307 of 2020.
Do that.
CRP 307 of 2020.
CRP 307.
Lord, page 47, paragraph 15.
Para number?
15. 1 5. Page 47. Whether a claim can be rejected under 7 to 11 of 6 on the ground of suit being expressly barred by limitation or in all cases limitation of the mixed question of law and fact requiring clarity. Extensive arguments have been advanced by counsel and several citations that we strike now that total limitation is mixed question of both facts and law, and the apex court and this court have taken off the said that limitation per se cannot be drawn to exercise.
15.4.
Please,
and then
any good reading of plain disclose suit is exercised barred by limitation. Powers could be exercised under so your lordship may kindly see 16.2. The registration of make is the public document and constructive notice 16.3. And 16.6. Such being the case when a document is registered by following due formalities, the document becoming a public document which will come out a constructive notice to one and all about such registration of sale. And 16.9. By the registration of sale in respect of alleged joint family property would amount to constructive notice to all members of joint family if the above conditions are fulfilled. Here he is not at all sought for partition also. So his case is too worse to Lord because he has also not sought partition and he admits that sale deed has been executed, that is not binding, and prayer column without seeking any prayer regarding sale deed say that I have become the owner. After execution of sale deed, what was the cause of action for the plaintiff to institute the suit? And 2019 SAR civil university. Raghavendra Sharan Singh versus Ram Prasan. 6.1. At the outset, it is required to be noted that the plaintiff has instituted a defendant for declaration that the defendant has acquired both title and possession on the basis of deed of gift dated so and so, and that the plaintiff has bought title and possession of said property. In the suit, plaintiff has made the following belief that on adjudication of the facts and about we declare that the defendant acquired both title and possession on the basis of deed of gift dated so and so. The plaintiff has got title and possession in the said property. Hence, all have been considering the evidence in the plaint. it can be seen that as such the plaintiff has specifically admitted that the plaintiff and his brother executed gift deed on so and so. It is admitted that gift deed is a registered gift deed. It also emerges from the plaint that till 2003, neither the plaintiff nor his brother during his lifetime challenged the gift deed dated nor at any point of time claimed the gift deed dated 6/3/1981 was a choice deed of gifts. In fact, it is the defendant apparently who issued the suit in the year 2001 against his brothers, to which even plaintiff was a party and defendant number 10, and that was a partition suit filed by the original defendant. It appears that someone copy and copy of the plaint was served upon plaintiff. Still, the plaintiff averred in the plaint that he came to know the knowledge of the plaintiff with respect to gift deed on 10/4/2003. Thus, it is borne out from the averments in the plaint till 2003 that he never disputed the gift deed or never claimed that gift deed was a solid deed of gift deed. The aforesaid facts and circumstances, the application submitted by the applicant original defendant to reject the plaint in the exercise of Order 7/11 is required to be considered. By considering the scope and ambit of the application under 7/11, few decisions of this court on Order 7/11 of CPC are required.
Yes, I've seen that.
And another decision, Lord, the Honorable Apex Court, Lord.
Where is Apex Court judgment?
This is Lord, 2020.
Which para?
Para 26.
Para?
26.
Have you given him all the judgments?
I have given.
Yes.
Article 58 and 59 of Schedule 2, 1963 Act prescribe the period of limitation for filing a suit where a declaration is sought or cancellation of instrument or rescission of contract which reads as under. The period of limitation prescribed under Article 58 and 59 of the Act is 3 years, which commences from the date when the right to sue first accrues. In Padri Hotels versus Union of India, this court had held that the use of the word first between the words sue and accrued would mean that if suit is based on multiple cause of action, the period of limitation begins to run from the date when the right to sue first accrues. That is, if there are successive violations of the right, it would not give rise to fresh cause of action, and the suit will liable be dismissed if it is beyond the period of limitation counted from the date when the right to sue accrues. The three-judge bench of this court, the state of Punjab versus Rejection, held that the court must examine the claim and determine when the right to sue first accrued to the plaintiff and whether on the presumed facts clearly is within that. The words right to sue mean the right to seek relief by means of legal proceedings. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit is infringed or when there is a clear and unequivocal threat to infringe such a right by defendant against whom suit is instituted. On 7/11, it provides that there is suit appears from the elements in the claim to be barred by the law, the claim shall be liability rejected. Your lordship may kindly come to paragraph 29.8. 29.8 and 29.9. 29.9 is enough. In view of the law laid down by this court, even if the elements of the plaintiff are taken to be true, that the entire sale consideration had not been paid to be paid, it would not be a ground for cancellation of sale. The plaintiff may have other remedies in law for recovery of balance assets, but would not be granted the relief of cancellation of registered sale. We find in the suit find that the plaintiff is vexatious, meritless, and does not disclose the right to sue. So, my lord, even if he alleges that any of the conditions or recitals of the sale deed is wrong, his right to sue accrued on the year 1967 itself.
What is the age of this plaintiff?
'58, 50, 47, page 26, plaint.
27.
26.
$58 years as on 2015.
Yes.
Sale deed is of the year 1967.
67.
So maybe he is 10 years old When the sale is executed, all these people.
Allah, I can understand if we institute a rule for partition saying that this is not
Not
a
binding
family
on that.
necessity. Then the things would have been different.
Will you hear? Yes.
I filed detailed objections today morning. In the candidate. Some of the material facts have been suppressed before this court. Before the sale deed that my defendant urges, there is already one more sale deed with respect to the very same property. Rejection.
No, we will not go into all that. We will only look at your plaint. Those facts are not necessary. From your plaint, we have to look at it.
From the plaint only. This
Let's
is
look
clear.
at your
This is
plaint.
clear. The sale deed that I am just mentioned.
Let's look at it.
Yes.
Let's come to your plaint.
Yes.
And first of all, right or wrong, there is a sale deed. Unless and until you seek a declaration that it is not binding on you, how can you maintain the suit?
The non-alienating members.
That is Shuru Singh's case you are referring to. You are referring to which case?
But last month one judgment is there, my lord, based upon the division bench of judgment of this court. May I take your
You do not require to seek cancellation because you are not an executive. You are not a party to that document. But what you are supposed to ask?
My lord, this court has said that non-alienating joint family members need not even challenge the certificate to which they are not parties. It is enough if they seek for partition. Merely enough.
It is not even a suit for partition.
Yes, but that is that we need not challenge the my lord.
This is not a suit for partition.
Yes.
You are seeking that. You are saying that you are the owner of the property and you are seeking recovery of possession.
Yes.
You are seeking recovery. No, you admit that there is a sale deed. What should happen to that?
No, sale deed is a
Is executed by your grandfather, who is the owner of the property as on that day.
No, it is not executed by all the joint family members. That is what I was saying. Lordship, can you objections today as produced genealogy? Genealogy. Not all joint family members have submitted. I will take your lordship to the facts first. Some of the material facts have been not disclosed. Lordship, can you see page 2 of my statement of objections?
We will not look at your statement of objections. We'll draw the attention of the court from the plaint. Come to the plaint.
Yes.
We'll see from the plaint.
Yes. Plaint paragraph number, amended paragraph number 2A.
And first of all,
yes.
In the main plaint itself, when you don't even question
No,
and say that you are...
In the pleadings, it is submitted that the sale deed is not binding on our share. That is also the pleading I will demonstrate. Last occasion I have said.
So you can have a pleading, you don't have a prayer.
No, the non-alienating members of the joint family need not seek for any specific prayer to that effect because they are not signatories. If they are signatories, no necessarily they have to seek for cancellation because they are parties.
That in the context of a partition suit.
Yes.
Not generally saying that seeking recovery of possession.
Yes.
Where is a partition suit?
Yes.
Where are you seeking partition?
The partition, the non-alienating members need not challenge, need not question because it does not. In fact, first of all, the sale deed itself is a fraudulent sale deed. I will demonstrate from the records from the plaint governments also. Fraudulent sale deed, and in the photographs I produced, they were never in possession. It's a sale deed without possession.
Then why are you asking for recovery of possession?
1961, my lord, since 1961.
No, why are you seeking for recovery of possession when they are not in possession?
My lord, it's an alternate relief. I've also sought for declaration of title and injunction also. Court can mod, after trial, court can mod relief whichever it's equitable. Lordship, I kindly peruse 1961. From 1961 till date, I have produced the house extracts.
Before you go further,
yes.
Court cannot mold the prayer of conflicting prayers.
Yes. Lordship,
Court cannot mold a conflicting prayer.
Yes.
You say that I am in possession of the property. Court will not mold the prayer and say, okay, we'll give recovery of possession.
Regarding possession. Lordship, I have produced the records from 1961. How if this property is not just vacant land, there is a house property more than 70 years old. There is an entire family residing in that photographs produced. Since 1961, we are paying the tax of that property. Produced statement of objection since 1961.
Then why you want recovery of possession?
Please, it's an alternate relief, my lord, it has failed. It is,
if you submit that,
yes.
If you submit that, your case has to completely go.
Yes. Lord, we are in possession. We are in possession of the property. Your lordship.
Shall I record that?
Please.
Shall I record in this order saying that it is a submission of the counsel for the respondent that he is in possession of the property, yes. Just like that he asked for his recovery or the relief of recovery of possession. Shall I record that?
Lord, I am in possession. There is nothing wrong in paying for an alternate relief. Because
please don't make that kind of submissions as if it has some authority of law. You have to verify and say.
Please.
on the legal position, just like that, you can't submit like that.
Insofar-
Because every submission you are making, as if that's law.
No.
No, that's not law.
My sincere apologies.
That's
If I
not,
am coming
you
across-
cannot say that, I can always seek an alternative prayer. That is not an alternative prayer.
Please, but insofar as
Recovery of possession is your main prayer.
Yes.
Basing on what you file the
insofar as possession is concerned, kindly peruse me. One minute, Your Worship, kindly peruse my statement of objections. I have produced the photographs. The house is more than 70 years old. 1961 house bill tax receipts I have produced. 1961 up to till date. We are in possession, and entire family is residing there. They were never in possession of the property. The land is also not an agriculture. It's not even a cultivable land. It's a waste land. Lordship, kindly see the photographs. It's a waste
You're not
land.
understanding. In a revision, court will not look into all
Yes.
these documents.
Yes.
We don't even have to file a counter in a revision.
Yes.
Because court
But,
will
my lord, since-
adjudicate basing on the material on record. And
Since-
court will not look into all that. Please come to
Since
your
one
plaint.
submission.
Please come to your plaint and argue.
Yes.
And basing
These
on
are all
the
our objections and whatever that I have submitted in the objections.
objections will not
They are
look
from the
into.
plaint only. My submission is they are from the plaint.
We'll
What
look at
I have
that.
explained in the
Please
petition.
come to the plaint.
Yes.
Let me look at the plaint. I'll please
Plaint,
tell
Your
the
Worship,
court.
may kindly see.
So there is a document from the year 1967.
Yes.
When did you come to know about that? 1967
Yes.
document.
My answer to that argument is that I never had the knowledge of this document.
Where did you say so?
Yes. I my lord,
Where did you say so
in
from
the
the
plaint, my
plaint?
lord, this document is a fraud document. I never came into knowledge because I was already in possession since last 70 years. If it is a cultivable land, if it's an agricultural land, if I am cultivating of he interferes or I interfere, then the question of coming to knowledge of whether a whose possession would come into play. Because since the land itself is an uncultivable land, nobody came to the land, and in the house, insofar as house property, I am residing since last 70 years. Nobody questioned my possession. Therefore, there is no question of
Mr. Counsel, please
Yes.
don't make that kind of submission. Please look at the page number 31,
Yes. My lord, the page.
31 of the papers.
Yes. Regarding the prayer. my lord.
And please read.
Yes. The defendants are directed to hand over the actual and vacant possession of the suit property to the plaintiff.
What is that relief?
This is a recovery of possession. Relief of recovery of possession. It's a relief for recovery of
When you
possession.
are in possession of the property, you file a suit against anybody.
My lord, first prayer is for declaration of title.
Where is the first prayer?
My lord, point 1. If we declare that plaintiffs are the absolute owners of the suit property, 1A is a consequent relief and there are also injunction. I have sought for all reliefs. Declaration of title and recovery of possession and injunction also.
That is one I understood.
Yes.
That recovery of possession, it's an alternative.
Relief.
What is that? No, alternative, something else you said.
It's an-
Recovery of possession, huh?
Yes. It's an alternate relief.
Though you are in possession of the property, you sought a relief.
Yes. Lord, it's
Understood.
when
Number 2, 1967 document. You don't know where it is, when it is, how it is.
1967, Lordship, kindly one submission. 1967, these LTDs of 1967. 1962, from the plaint government, I am reading, para 2A, plaint government para 2A. From the entire land is 32 guntas. Already 2 guntas of the land has already been, from the very same subject property, there is a registered sale deed in the third person, very same property. Their sale deed says that the entire extent of agricultural 32 guntas is what is sold to them. One, that the land is not an agricultural land. Endorsement I have produced along with the objection. 2, the land is not entirely.
Please don't argue that you are arguing the suit.
Yes.
You are on a petition under order 7 to 11.
Yes.
Come
Yes.
to that.
Yes.
Those are not the issues to be
They are not
considered.
issues, my lord, it's acts that are suppressed. That is what I am.
Suppression is not the question. We are looking at your plaint. It's not their plaint of
From the
suppression.
plaint, 2A, para 2A, whatever that I am submitting. What is
Please understand, speak about argue on the legal proposition. 1967, when you are referring to a document
Yes.
and seeking recovery of possession. So alternatively, as you say, you should say the limitation has to be recorded.
limitation, Article 65 of the Limitation Act. The limitation starts when I seek for recovery of possession. The Lordship may kindly say Article 65 of the Limitation Act. The limitations commences.
That you
from-
should say, Mr. Counsel, in the plaint.
But it's only, I would say,
That is, you should say in the plaint.
It's
It is not that you file a suit that the day it commences. You should say that the 1967 document has come to your notice on so and so date, and you are filing the suit.
This was argued, my lord, in the earlier round of notification.
That this court
Yes,
is not
that is
concerned. Now we come to that.
Yes, 1967 salary, my lord, it is 1967, before 1967 there is a salary, and the persons, my lord, all the joint family members have not executed the salary.
When did you say so? When did you come about it? How you verified? When did you obtain the documents?
Yes.
When you come to know that
In the-
this is
in
not
the-
signed by
yes,
all of
yes,
them?
yes.
When did you
I
say? You know,
Para
there is a procedure for everything.
Para 2C. Thus, it is submitted on the basis of the alleged illegal document name of
As on the date when you filed this petition, your grandfather is alive?
my grandfather on the filing of suit. No, he was not. He was not.
When did he tell you that he has not signed it?
No, the sale deed is executed by my grandfather and one of the person. There are two other persons who have not executed. That is
one aspect.
Yes, that has
You
to be
say
done.
that the signatures of my grandfather are not. No, you are deriving your right from your grandfather.
Yes, it's an ancestor.
It's an ancestral property. Then what you should generally ask that it is a joint family property, that my share has been sold by my grandfather. He has no right to do it. So that sale deed is not binding on me. So partition the property should be your relief. Without anything, how can in this manner the suit can be maintained?
We are in possession, undisturbed possession, therefore there was no occasion for us to file this suit.
It's all your arguments are suicidal to your client. Because you cannot say by filing an IA, seeking amendment of plaint, seeking recovery of possession, and you say I'm continuously in possession of the property. You can't afford to say. You can't. You cannot say that I'm in possession of the property. You are not in possession of the property. For that recovery of possession, you are not in possession of the property. Otherwise, there is no reason for you to seek this IA. You cannot call it an alternative prayer. The recovery of possession can't be an alternative prayer.
In that event, my lord, I can, insofar as that prayer is concerned, I can also take, my lord, that prayer can be not pressed by the plaintiff also, because we are only seeking for declaration of title and injunction. Since we are already in possession, my lord, in the trial court, my lord, whatever the instructions are given, that is there. But because of that, my lord,
what will happen to that High Court order?
Please.
Why did you file a petition? What is
happened
happened to the order?
All these aspects were argued before the.
Because it is a pure, going for trial is a pure abuse of process with these kind of aberrations.
This possession is not, I produced the documents also. Since last 70 years, the entire family will be thrown out because they have come to the house property with the JCB. That is why we are filed suit. Because there are about 5 to 6 children in the house. We are residing since last 70 years. Possession is not at all disturbed. The land is not cultivable. They never came to land. Although there is a registered sale, they never came to land. Lord, at least, my lord, when we
At what stage is the suit now?
No, in fact, earlier, one more.
What is the stage of the suit?
Lord, statement is filed. Written statement is filed.
There is a direction by this court to culminate the suit in 6 months. So that also produced. In the earlier, the first writ petition where the injunction order was granted.
How can the suit be decided in 6 months?
That is the direction, Lord. It's not being cooperated now. Your Lordship, page 40, in the objections, my lord, are produced. Already there is a direction by this court to conclude the suit, page 27. This was when the trial court had granted an interim order. This court protected my possession by granting status quo insofar as house properties are concerned, and directed the trial court to dispose this as expeditiously as possible. Now we are ready to cooperate with the whole court disposal. Your Lordship may kindly fix a time frame and.
What time frame? What is the suit? How can the court decide all these issues and the manner in which it is framed?
Undisturbed possession, we are not. It has to be decided, my lord. And insofar as the judgment, the Learned Counsel for Petitions relied upon CRP judgment, identical set of facts. And CRP Lordship just referred. CRP number 168 of 2019. This is Durga Project's judgment. Identical set of facts. Where this court has held, in suit for partition, you have to necessarily seek for declaration of the challenge the sale deed, and if there are also old sale deeds to challenge, this court allowed the CRP and dismissed the suit. That went in appeal. I have produced the memo of citation. The Supreme Court has categorically held
identical set of facts.
It is not a suit for partition to be identical circumstances. Yours is not a suit for partition.
This is not a suit for partition, but the sale deeds were challenged after lapse of several years. That
No, that is
under
okay,
such circumstances,
that
Supreme
is-
Court has held. Supreme Court, the order.
Take that.
Citation. Earlier, I have given citation. In the morning, along with my statement of objection, may I take it also? But this is the order passed by Supreme Court in this very same CRPT.
Yes.
This is the CRP. The order that passed.
Yes, understood, yes.
May para 2 madam. Same government. Plaintiff further submits the already stated above inquiry and plaintiff defendant.
Is it this?
Yes.
Which judgment you are referring to?
First, very first. This is the order of the Supreme Court. This.
Yes.
There was also a registered sale deed. The allegation was it's a fraud and forgery of payment, and this court has dismissed the suit and it went in appeal. And the Supreme Court set aside by holding that it cannot be decided like that. It is well settled that while considering the application in 7 to 11, the averments of the plaint alone are examined and no other extraneous factor can be taken into consideration. On the basis of averments made by the plaintiff, suit mentioned, we find that it is disputed question of fact as to whether the agreement for sale, the power of attorney, and the sale deeds are forged and fabricated. Such questions are required to be decided on the basis of evidence led by parties. We do find that forgery pleaded cannot be ground for rejection of the claim. In view of this effect, order passed by the High Court.
How is it useful for you?
It is useful because the Lordship petitioner submitted that the sale deed, registered sale deed is that we have to seek for cancellation and challenge that sale deed 1. And also in similar circumstances, the claim outrightly was rejected, by this court. It was carried in appeal and the Supreme Court has set aside. Now, the next judgment that I am referring is on limitation. When the question of limitation is a mixed question of fact, it cannot.
That is not your submission.
Yes. Yes.
That is not your submission. Mixed question of fact and law is that is a settled law.
Yes.
Your submission is you don't even plead when it is.
Yes.
You don't even plead when you came to know about that 1967 document. There is a question of limitation in that.
The cause of action paragraph, plaintiff has mentioned.
You simply said 2015 when they came to dispossess me. Your claim should contain when you came to know about the document. When did you apply the certified copies of the document, or when did you do it? Without that, that means 1967 document is in your knowledge from a very long time.
We never.
That you should say. That you should say.
Plaintiffs are belonging to marginalized community. None of them are educated. Now the first generation children are being educated. Now, old 1967, they were having no knowledge about it.
I think they have come to the advocate to draft this plaint. They have not written the plaint. You are referring to the marginalized section of the people. They have not drafted the plaint. It is drafted by the advocate.
Yes.
So advocate should say when is their notice.
Yes.
Because that's the basic thing which the plaint should contain.
It's mentioned, without limitation, they never had the knowledge for simple fact that since last 7 years.
Then how come you know about this 1967 document that is not executed by you?
Yes, when they started.
Please understand, Mr. Counsel.
Yes,
That's not the way you argue the
when they
matter.
my submission.
Where did you say so? That you please tell the court.
Yes, please.
Where did you say from the plaint to tell the court?
Please, I will. May I read paragraph 2 beyond?
Yes.
Paragraph 2 beyond. Lordship's kind permission.
Yes.
Further, it is affected that grandfather of the plaintiff by name of Hanmantappa Revappa Lagli and his elderly son Siddhappa Hanmantappa Lagli are illiterate and rustic villagers persons along with they are not educated and not known regarding the reading and writing and taking undue advantage of this fact in the year 1967. The father of defendant number 1 and grandfather of defendant number 2 to 4 by name Ningappa Sangani, scribe and witness, God created a false and fabricated document styled as sale deed in favor of Ningappa Sangani. On going to this alleged document, it is specifically mentioned in written that non-agricultural land is suit property. Moreover, the suit property in question till today is an agricultural land and it was not at all converted to non-agricultural land till today. There is no any NA order or notation entry available to show that. the suit property in question is not converted to non-agricultural land, then the question of execution of the alleged sale deed by ancestors of plaintiff in favor of Mrs. Nilappa Ningappa does not arise at all. Therefore, it is clearly goes to show that the alleged illegal styled as sale deed in favor of Mrs. Ningappa Samaki is a false, fabricated, and concocted. The contents of the alleged sale deed illegal mentioned document above mentioned are false, same, and denied by the plaintiff. The grandfather of the plaintiff by name Hanumantappa and his elderly son Hanumant have not at all executed any alleged or and illegal document in respect of the property in favor of father of defendant number 1 and grandfather of defendant number 2.
Where did you say that? When did you come to know?
Yes, further awareness. Hence, the alleged document have what we have executed by defendant number 1, grandfather Nilappa from the grandfather of plaintiff by name of his elderly son is void as mentioned, not binding on the plaintiff.
Yes, we'll pass orders. So,
Cause of action, my lord, also 2015 when the defendant.
yes. Next part. Reserve, third reserve.
Number 77.
One last submission, to lordship's kind submission. Rejection of the plaint outrightly, without giving an opportunity for trial would be unjust on their part because there are children living in the house.
Yes,
Please.
Yes. What do you say? I've seen. Please come. The present writ petition is filed. Signature of registered quashing the order dated 5/1/2023, passed in appeal number ECS/05/APP/2022, passed by the first respondent. The facts of the case are the petitioner is a registered partnership firm and they're having a CL7 license in terms of Rule 37 of the Karnataka Excise, within brackets, sale of Indian and foreign liquor rules 1968, which is for the hotel and boarding house liquor service facility. Initially, the partnership consists of 2 persons by name Pola Radhakrishna and his wife Srimati P.R. Padmalata. On 18/4/2012, their son by name Pola Nagarjuna was admitted as a third partner with 15% of the profit sharing ratio. Treating the same as a transfer of license, the third respondent issued a notice of demand hearing date on 18/1/2015 and demanded a sum of rupees 5,80,000 and 87,000 towards the transfer fee. The petitioner had given a reply dated 23/1/2015, denying the liability to pay the said amount as per the demand. Thereafter, another order was passed reiterating the demand, which was questioned by the petitioner by filing appeal before the first respondent appellate, that is the appellate authority. The appellate authority heard the appeal and allowed the same in part, and the remanded the issue to the third respondent to decide a case by order dated 2012-2014. The third respondent once again passed an order dated 25/2015, reiterating the demand. Thereafter, the petitioner has approached this court by filing WP number 4548 of 2020. Initially, this court had disposed of the same by directing the respondent number 2 decide the matter in the light of the decision of this court in WP number 30590 of 2014 and WP 56657 of 2015, dated 22/5/2017, wherein this court has decided about what amounts to transfer and which attracts section 17(3).
17B.
17B. Thereafter, notice was issued and an order was passed dated 1/12/2021 and directed the refund of the transfer fee collected from the petitioner at rupees 5,80,000 and 80,000 respectively. By following the judgment of this court. Thereafter, on 13/12/2021, the petitioner had made a request for refund of the amount so collected, and the said request was not considered. The petitioner has filed WP number 1000388 of 2022. Then an order was passed directing the commissioner, deputy commissioner, to implement the order dated 1/12/2021. It is stated that thereafter, designating himself as the state of Karnataka, the deputy commissioner of Excise Ballari district, that is the third respondent here, and presented appeal on 5/1/2022 and questioned the order of the deputy commissioner before the first respondent. The first respondent, without considering the errors pointed out in presenting the appeal by the third respondent, in the name of the state of Karnataka, has passed an order dated 5/1/2023, allowed the appeal. That order is in question before this court. It is stated that before this court. Next paragraph. Senior counsel appearing for the petitioner submits that the said order is erroneous and beyond the scope of appeal under section 61(2) of the Karnataka Excise Act. Further, it is submitted that when the issue in question is clearly covered by the judgment of a coordinate bench of this court in case of Messrs. Shankar Wines, arising out of petition number 30590 of 2014, petition number 56657 of 2014, dated 22nd August 2017. The first respondent has failed to consider the said judgment and entertain the appeal filed by the third respondent and has passed the order issue. The senior counsel has drawn the attention of this court to the said judgment. They relied particularly paragraph numbers 18, not 18, paragraphs number 15, 16, 17, 18, 19,
21.
21. Till 22, extract from the order. Relying on the said judgment, he submits that in this case, the son who has entered as a partner, he is entitled for 15% of the share. The section 17B is attracted once, that is the incoming partners, the share is beyond 50%, and the learned judge had observed at para number 18 of the order that as long as existing partners do not divest themselves to 50% or more of the stake in the partnership firm which holds the license in question, The transfer fee applicable under Rule 17B of the rules will not be retracted or will not be payable. Next part. In the same paragraph. It is further submitted that pursuant to the order passed by this court, the state of Karnataka has come out with a GO. What is that? Come out with the GO, wherein come out with the notification by amending the rules dated 16th August. Observed by this court in the judgment of Messrs. Shankar Wines Refer Supra, that the very same clause is incorporated in the said rules by way of amendment. Even in the light of the said rules also, the petition is entitled for the refund of the amount. Next paragraph. Learned Garment Peter established that the rules that are relied on by the petitioner are prospective in nature and they cannot be applied retrospectively. Considering that there is a person, the son has come into the partnership firm and as per section 17B of the Act, it amounts to transfer, and the appellate authority first respondent has rightly passed the order. Now in this compilation, where is that order? Page number?
Please, my lord. That Deputy Commissioner order.
That is the order impugned. Where is it?
Impugned order is, my lord's page number 49, Annexure J.
It is in English?
Yes. English.
49.
Operative portion is English. Yes, page 60 is the operative portion. 49, Annexure J. Last document.
Yes. Having got the learned senior counsel for the petitioner, the learned counsel, the Garment Peter appearing for the respondents, that is the entire material placed before this court.
In page 22, it is clearly considered. Page 22.
Of what?
The impugned order.
Paragraph
52, page 52. It was clearly considered. I may permit to read, madam. In compliance of in compliance with the order of the Honorable High Court in the writ petitions also, this authority wide out retained has already directed the third respondent therein and the appellant therein to refund of rupees 6,67,000 limited by the second respondent for the changes made in their partnership firm as per the reconstitution deed dated also. However, the refund was ordered subject to the final verdict in this appeal filed by the appellant before this authority was ordered by the Honorable Court. Under section 61 subsequent to Karnataka Excise Act 65, any aggrieved person, including a deputy commissioner of excise, is entitled to file an appeal against an order passed by the deputy commissioner of revenue. Therefore, I am of the
what is the senior counsel? What is decided by this appellate? He says there is a judgment. He will set aside the order of the deputy commissioner, and he says that to recover an amount of 6,67,000.
Deputy Commissioner of Excise is subordinate to the Deputy Commissioner. Deputy Commissioner is the collector, who is the licensing authority. His order is questioned by the subordinate, designating himself as the State of Karnataka. State of Karnataka is the Chief Secretary, Additional Chief Secretary, and the Secretary of the respective department. Deputy Commissioner of Excise.
So that is one part. On what basis? What is the reasoning for setting aside the order?
There is no reasoning. The Commissioner himself instructed the Deputy Commissioner of Excise to file the appeal. That is my information.
Therefore, I am of the considered opinion that the demand notice dated 25, 2015, which was referred is in accordance with the judgment.
How can it be in accordance with it? How can it be in accordance?
At least they have to mention and they have to inform to the department.
It is not all that. The case where that your commission should be taken to task for blatantly violating the orders of the court and exercising these kind of, isn't it an abuse of process? What kind of a litigation is this? How can they pass these kind of orders?
Earlier they have approached the revenue DC madam. Revenue DC has passed them.
I think there should be some application of mind. Look at the order, what is the order the court is saying? And how come this is going on from 2012?
Yes. The district collector made a very detailed reasoned order. District collector's order is there. Yes.
Against an order passed by the Deputy Commissioner Excise. Who has filed this appeal? Deputy Commissioner Revenue.
No. Deputy Commissioner Revenue passed the order in my favor. Who is the competent authority? That is questioned by Deputy Commissioner of Excise, third respondent, calling him as the state government. He should be aggrieved under section 61(2).
Some strictures on this officer for filing kind of an application.
Yes, cost has to be imposed, and he cannot call himself as a state Karnataka.
Where is he now? Is he still working?
No, he is working. He is in office. Maybe transferred, but he is in office. And this district collector was very much a very highly dignified officer, having knowledge of rule of law. His order is challenged by the subordinate officer.
No, at least you can tell the court, can the state of Karnataka Department of Excise, this Deputy Commissioner of Excise can be representing the state of Karnataka?
No, Chief Secretary, Additional Chief Secretary.
Let the government leader say that.
Excise Department is not representing. Revenue DC is representing the state of Karnataka.
Look at it. I'm looking at the cost title and saying, I want instructions on this. I want instructions from your, there will be a principal secretary or no principal secretary? Is there no? Please ask your principal secretary, what is this? Court wants to know how will things happen in the department. Court at least has to understand. Please come. Let it be as it is. Against the orders passed by the order passed by the Deputy Commissioner Revenue, the Deputy Commissioner of Excise, naming him as representing the state of styling it as a state of Karnataka Department Excise, represented by the Deputy Commissioner of Excise, files an appeal before the Excise Commissioner. And an order is passed, dated 5/1/2023. The principal secretary, the government leader shall get written instructions from the principal secretary and place the same before the court, whether it is the deputy commissioner of whether the deputy commissioner of excise can represent the state of Karnataka. If not, and whether such an authorization was given by the state of by any other authority, and under which authority he has filed this appeal before the excise commissioner, and the written instructions shall be placed before this court by 28th of November. This is matter that whatever I have dictated, not type it and read it. We'll continue that.
27th.
27.
In the other matter, I am there before my notes.
27.
Please.
Yes, next. Eighty. Give that file. Before we continue this, shall we call this the next matters? So that it we just, for orders they are coming, call it, yes.
This number. This number, orders matters, seal number one. And you have to
Give that. Memo is fine. Seeking dispensation of notice to R2 to R8. Accordingly, memo is taken on record. Notice to R2 to R8 is dispensed with. And the petitioner has also filed a memo having served a copy to R1 council. So HP, HIPPR something, that name is there in the call status. The list is matter for admission. When the name of the council for respondent one as so and so, as listed in the causes. List is matter for admission on 25th and on Saturday 23rd. Yes, next.
Seal number 2, provision
What is this? Paper publication not access.
The paper has been published after the 4 days. Last date was the 21 days. We have published in 5 days.
Any of published with data?
The respondent is a resident of the Dharwad.
Which edition is this? Vijayawani Bangalore edition.
Bangalore edition.
As per the order passed by this court, petitioner has taken out paper publication, Vijayawani Bangalore edition. According to and filed a paper publication. The same is taken on record and notice to taken on record and notice to respondent is held sufficient. List is matter on Saturday for admission. Yes, next.
Serial number 1. Kindly date note.
What date? It is already given. Yes.
Anyone is seal number 3, 400. 400.
Give that. I have 1 of 24 is 5. Is filed, published of the court, is filed an application to take out notice by way of substituted service on the respondent in Vijayawada Dharwad edition. Accordingly, IA number 1 of 24 is allowed, and the petitioner should permitted to take out notice by way of substituted service in so and so daily on or before, yes, dates on or before 15 days from today.
4th December.
On or before 4th December, mentioning the date of hearing as 18th of December. Yes, next. Yes.
Serial number 4, again serial number
3.1. Needful shall be done within a week or else the default order. Next.
Serial number 5.
No, it is on 3.1. What about 4?
4
Adjourn in the morning, yes. Next 5.
Serial number 5.
Let this 5 and 6 come tomorrow. Simply, this is matters tomorrow. Next.
Petition number 7.
Yes.
Capital.
You appear? On this matter tomorrow, this matter tomorrow, next 8.
Still number 8.
Yes.
In the last occasion, I argued this is rejection of plaint. Is required documents to be produced. I produced the documents along with the plaint and written statement. So we have a declaration of adverse possession and permanent injunction, rejection of plaint, which is already decided matter in the OS and FDP proceeding. EP execution petition is pending and compromised already declared that they have.
You are the defendant in the suit.
Please.
What is
I am the defendant number 2 here.
What is the suit for?
Suit for declaration and adverse possession of permanent injunction. This matter suit for plaintiff was due out of cause of action, and plaint was filed. And Lavanya under CPC plaint was rejected and dismissed for unreasonable cause of justificata, your lordship. OS has already decided.
No, please don't jumble all the facts. No, suit is for declaration.
Declaration.
And also it's claiming on the adverse possession. Then you have filed an application under Order 7 Rule 11.
No.
On what ground?
I have filed for the application for plaint OS. Application is filed for the rejection.
Correct. On what ground?
On the ground that that is included the one of the unsustainable and not consider the litigation, and it is litigation.
Please draw the
dispute
attention.
Is regarding the property is not. We already decided, your lordship.
You know the facts of your case. You know the facts of your case. Court do not know. Unless and until you come to that particular paragraph and show the court, court cannot understand.
Please
come to the application under Order 7 Rule 11.
Annexure
Page number.
Application hearing, application.
Page number 20.
May I read it? Hearing the application on behalf of the defendant.
This application, you have not stated not even one reason why that it has to be rejected.
Yeah, I have stated in the application.
Please look at it. Which para?
In the affidavit paragraph number 2, your lordship.
Para 2 is plaintiff has filed a frivolous suit. That cannot be a ground. For every defendant, plaintiff suit is a frivolous suit. Why it is a frivolous suit?
In the further same I state there is no cause of action for the present plaintiff to institute the talk in the.
Where is the plaint?
That is in the paragraph 3 of the affidavit. Kindly see, your lordship.
The counsel, where is the plaint?
Plaint is annexure A. Plaint is here.
Page number 1.
The cause of action arose in the month of 2022 when the defendants filed compromise petition and the objection of plaintiff was overruled, and also subsequently when they tried to dispossess the plaintiff from the suit property. Are you a party to the FDP?
I was a party, my lords. Sir. In that suit, my lords, defendant number 1 has executed an unregistered sale deed. He has put me in possession.
No, please.
I was a
For the
party.
understanding of the court.
I was a party there.
Now, the suit scheduled property is a part of the FDP proceedings or not?
Yes.
Then how can you file a separate suit like this?
There was a partition. Now I have set up to my next violate adverse possession. I am not having the title. I am not belongs to the family of.
No, you have already contested the suit.
On the basis of my notes, I am a suit owner. I contested it.
You cannot, when you are contesting something and this defendant is also a party to that suit, how can you set up a different story now?
No, the reason is this. There, my notes, I am a purchaser. I came before the court myself filed application. Court said it is an unregistered agreement, sale deed. You have no right title, but you are in a possession. But based upon that, my lords, I filed this suit, my lords.
Is it maintainable
My lords, my
between the
submission-
very same parties?
No, sir. Only my actual submission for this one for this. So far as order 7 rule 11 is only, my lords, that is, my lords, I cannot.
No, what did you say in your plaint?
That
Let's
is-
look at the plaint. You yourself are saying the cause of action arose in the month of 2022 when the defendant filed compromise petition in FDP number. The objection of the plaintiff was overruled and also so on the face of it, without looking at what she is saying. No, that's why the court asked, looking at your cause of action, being a party to the final degree proceedings, where yourself and the defendant in this suit are parties, where the court has adjudicated with regard to the suit scheduled property.
Suit scheduled property is one of the subject matter,
No.
But my contention, my lords, I am not the joint company or nothing. I am a purchaser. I was implicated, my lords.
It is not like that. If it is a partition suit, one set of evidence, and then once a party, then you want a declaration, another set of evidence. No.
But that everything I have pleaded in my plaint. Here, my lords, in the plaint I have specifically mentioned. Good sir, I am an intending purchaser, I purchased it. Lords, I have put in the position.
You have to, when they are seeking, when they made you a party, a purchaser, whatever
No,
that
they have not made me, myself had.
anyhow, whatever it is, you've been there before the court. Whatever grounds you are urging here, you are supposed to urge there. Once having not taken any of this, now it is not open for you to say anything.
My submission. When that is considered, that's a matter of.
No, not at all. You said so. You're saying that you're a party. You're saying everything. On the face of it, how can you maintain a suit? That's the first question.
One is the second suit is hit by res judicata. It is also a matter of what you said, cannot be filed as a.
So let me differ. At all times, cause
of action for filing this.
No, that's what we'll see. We'll see from your plaint what is that declaration of adverse position.
Adverse position.
And permanent injunction. Let's see. You're saying everything in your suit. Everything in your plaint. No, you can understand, you have not disclosed all this. And they're taking something like res judicata and other issues, and for that, court has to look at the judgment, look at that and this. It's not about, a separate suit is not maintainable, first of all, between the very same parties. When you are impleaded, when you got impleaded before the court, and it's a suit for partition, then you have put forth your case before the court. Basing on that, court has passed some order. It is your case that you have perfected your title by adverse position. You should have filed an appeal against that.
My adverse position I cannot plead there. Since my vendor.
No. Definitely you can plead. Whatever your
my
position.
vendor has admitted, my lords, he says, I have executed an agreement of sale and my lords based upon.
Then what you should say? What you
Here,
should
my
say?
lords, in the partition suit I contended, my lords, when the vendor said I have executed a sale, but it was unregistered. It could not be materialized, be expired.
You should have always as well pleaded in that I have been in possession of the property. I have been in possession of the property. From the last several years I am there. So I perfected my title. If you have taken such a plea, what would also consider that?
For seeking adverse position, my lords, I cannot, my lords, approbate and forward unless I admit that.
So, because you can't approbate and reprobate there, you are not permitted to do it.
Second round of litigation.
You are not permitted to do it at a later point of time.
I am not saying here, my lords, when this is hit by res judicata. Unless, my lords, this is proved, I am saying whether this issue which is required to be adjudicated, whether I have pleaded whether this contention was available in the earlier suit, that is the matter of trial. I can only mention this adverse position.
In every case, that issue cannot be a question of trial. On the plain reading of your plaint, you say.
Presuming, my lords, I am not saying, my lords, admitting that, my lords, I have admitted to ownership of a defendant number 1, that is the father of the here, my lords, I have admitted they are the owners. Once I admit, my lords, he has executed a sale. I have set up to my plea based upon that I am a owner. Where, my lords, court holds no, yours is unregistered, you can't be.
Court has taken such a plea. Does it mean that you should file another suit? You should have preferred an appeal against that.
That is mine, it's unregistered seal. I cannot.
You cannot do it, what you can't do it directly, you cannot do it indirectly also.
For a moment, notes presuming, notes when my notes, I am not having the title against a dependent number in that suit. Notes now the LRs are contained in that notes, I am in the possession, anyhow notes in the execution they are going to evict me. Notes one.
In respect to that particular property, and what is the purpose of impleading the subsequent purchasers or who are in possession of the property? Now what has happened, the suit for partition has been decreed. Court will execute it. Now the execution proceedings, it will be executed. Now, for the very same order, now another order will be passed in this judgment, in this suit, contrary to that. Can it be? Let's understand like this. Now, that is already decreed, you have not preferred any appeal. Whatever is the decree, the court will initiate the execution proceedings. Accordingly, it will be executed. Now, in the meantime, you will file this suit, and the court will pass an order contrary to what has already been passed by the other court, and now there will be conflicting of judgments between two courts.
Only my respectful submission, this contention which I have not asked in the earlier suit, that can, notes, that is.
Is it by order rule, order 2 or order?
So that difference, this instance cannot be, notes, that is taken.
I can understand in a different scenario, but yours in a black and everything you have stated in your plaint, which clearly attracts.
I am not saying notes, even if it is hit by order 2, my lords, at least there must be an adjudication to show that, my lords, this contention was very well available.
That's what the court, no, I will give that finding.
Only I requested on Monday, notes, I will place any authorities, otherwise, my lords,
No. Saturday. Why, if nobody wants to argue on Saturday, what the court will do on Saturday?
It may be taken as parted, yes.
Heard the counsels in part, this is matter as parted on 28.
20.
Yes.
Please.
Yes.
Seal number 9. Case part. Rejection mode.
Some 1,25,000 as per the order dated.
This sir has not deposited.
Has not deposited. Then we will vacate this. As per the order dated 12/9/2024, the petitioner has not deposited the amount. Accordingly, the stay granted by this court stands vacated. List this matter for final hearing after winter vacation. Yes.
Number 10.
What are these two matters?
Please, my lords, this is husband's petition.
No, these two we will hear it tomorrow. Some parted matters. This is matter tomorrow. Yes, for that matter.
The first place, my lord.
Huh? No, there won't be these many less. Only today it is there because it is after 5 o'clock. Yeah. Yes.
Number 18.
Yes, read.
Pair number 10, page number 23, pair number 11. Pair number 10, it is our that order dated 7/11/2012 has placed it aside to continue the personal bond order is placed in society in particular and in general in the public of the town. That the legal notifications are not binding on the plaint because quite contrary to circular dated 23/2/2012. That the issuance of increase order dependent on and to be with the help of others suit for invention required 10 of 2012. That further as the suit was not available, directly dependent on 3 and 4 and other. Another person withdraw therefore the plaintiffs are constrained to file these two for cause of redress. It is our that order dated 7/11/2012 was obtained behind the back of the plaintiff without giving the management members of the suit trust society. That moreover, work board and its secretary are silent despite the acknowledgement of the notice dated 7/8/2013. That the work board has also not yet decided the resolution of the plaintiff moved under section 40 of the Work Act, hence this suit. In response to the suit summons defendant number 1 to 4 appears to their counsel, it is contested by the Defense number 1 is to that scientific is made in the plaint are all powers, privileges and legislation. True property is an educational trust registered under the erstwhile Bombay Public Trust Act founded by one is the NH and others. That the food properties were purchased by the Muslim Jamaat by contributing the amount and was registered under the BPT Act. That after the repealment of the BPT Act, said the MH issued bought said food society and property registered under the Work Act on 1/6/1968. That the registration notice was issued by the board and on 4/8/1968 the general public and the board has received reply on by 26/8/1968 and then the matter was reported to the Deputy Commissioner Belgavi for submission of the report after inspecting the property and verifying the entire record. That the Assistant Commissioner submitted in the report stating that the two properties are work properties managed by the committee and the chairmanship of one Mr. M. that the education fund bilingual was named as Tanzim Education Society Bilingual. That number 30 it is contended that at the time of registration, the copy of the original registered sale deed of the land purchased in the name of Muslim Jamaat was produced and the nature of the work was shown as charitable and the name of the trust was shown as Maulana Abdul Kalam Azad High School. That the Tanzim Education Society along with its movable and immovable property after the completion of all the formalities was notified as a work property under the Gazette notification dated 18/5/1979 at page number 48. It is contended that the Food Society thereafter established educational institutions with an intention to impart education as per its bylaws and its rules framed thereafter. That the register under a BPT Act, Bombay Public Trust Act and Gazette notification has not been challenged by anybody in 2013. If any person is accused by the notification, then the notification is required to be challenged within 1 year from the date of its notification. Paragraph number 15. It is considered that the plaintiff has no open standing to file the suit as they are nowhere concerned to the sued work property and they are not having any manner of right, title or interest in and over the sued property. That is, really they were having any interest in the sued property, they would have kept mum for a longer period of 45 years without challenging the registration of the Bombay Public Trust.
Mr. Kant, please come to the act and tell the court what is the procedure.
Number 12, the procedure that was adopted by the institution is coming forward.
No. Let us understand. No. We'll first look at it. Let the court understand. Because you're the person who are saying that you say that it is notified as a work property and it's a work property. So for notifying a property as a work property, what is to be done, when it is done, how it is done, that the court wants to know.
That reason without the 1954 Act is required to be introduced before this court. This is the institution of the year 1968. This Act came into force
Before the tribunal, what are all the documents that are marked on your behalf? Let's see. What you have marked is CC of order sheet in PCR number 49 of 14, nothing to do with. 2 is the public notice, proceedings of 2013, Karnataka Gazette, certificate of registration, order dated, give the record.
Gazette notification of 1968.
1968. Record is not there.
By this court order dated 12/4.
It must have been when it is listed for final hearing.
To the best of my understanding, 12/4 was the order for filing for this Act.
Take out this. This public notice, RW exhibit.
D series and D series.
D series, exhibit D1.
Exhibit D1 is the order sheet, certificate of order.
Let's give that as it is.
PCR 49 and 14.
This is of the year 2014. It is some complaint. That we will not consider. Then after that,
Public notice.
where is the public notice?
Second document.
Public notice, Karnataka state. This is also in the year 2012. This also will not consider. What is, we will look at.
That is the order where is the verification of the cause of action on the basis of this order.
So what is your,
This is the basic notification.
yes. That is of which year?
Of the year, I have produced along with my appeal memo also. In the CRT.
No, I'm looking at it. Which serial number?
4, my lord. The serial number is 48, my lord. 48. This is the latest notification dated. That is March 14th, 1988. Title of the
19?
Karnataka Gazette.
Date.
March 14th, 1985.
14th March 1985. You are referring to something in the year 1969.
That was the proceedings that were concluded for getting the property registered in the year 1968 itself. The property was purchased.
This property belongs to whom?
The Jama. That is the local Jama who contributed, collected funds for the purpose of establishing the education institution. It is not the case of the plaintiffs that they are the one who established.
When, where and how the property is endowed to the
This is the para number 12 of the judgment that refers to the proceedings that have taken place for getting the property registered. I am coming to that.
This property, when you are claiming that a particular property is a work property, there is a procedure contemplated under the Act. Mere notification is not sufficient. First of all, there should be an origin to the property. Somebody should have endowed the property. What is the document?
Page number 63.
No, not the discussion and any amount of oral evidence cannot be looked into.
Say the basis of the entire purchase was on the basis of a registered sale.
By whom?
By the Jamaat in the year 1968 itself.
1968.
Registered sale.
When he endowed it to the Waqf?
That is on the.
You must be having a register. For example,
I shall produce the.
You should have done it before the tribunal. No, if a particular property is a Waqf property, then what are you doing with it? Periodically, there shall be notifications, there should be a register maintained, and how it has been happening from 1969. And when, on the contrary, the plaintiff, they have been running the school. There is enough evidence to show that they are in possession of the property. What are you doing when they are in possession of the property?
As to the property being registered as per the law. That is the document, gazette notification is coming for. That is dated 14th March.
If you want to place the entire proceedings with regard to this particular property, then there might be a chance for this court to interfere. Otherwise, as it is, this petition has to go.
I shall endure to
make it, and I'm already expressing my mind. Without that, it has to go. Land Council appearing for the petitioner seeks time to place before this court the entire record pertaining to this particular property, which should have been done before the tribunal, not here. You don't do anything and simply. You, in the sense, your counterpart.
No, I cannot blame anybody.
Not even your counterpart, your Waqf, your state Waqf, what is it doing? Yes, next.
2 weeks time around.
This is matter on 10th of December. Yes, next, 83.
Number 83.
Yes. Who appears to the respondent?
Mr. Bahubali.
So,
only short question is whether grandson can claim for partition
during the
lifetime of father without the assent of the father. Yes.
Counsel for the petitioner is present. This is matter, no representation for the respondent. This is matter tomorrow. Tomorrow is part 1. Yes, next 85.
85. Moving.
Let's see tomorrow. Other side is not there.
Except tomorrow, my lord.
Saturday. This is matter on Saturday. No representation for the respondent. Counsel for the petitioner is present. This is as part 1. Interim order earlier granted is extended till then. Just look at it. If it is there, extend.
Please.
Done.